Good afternoon, colleagues, and good afternoon to our witnesses. We are now going to resume our study of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts. And it is a pleasure to welcome our witnesses for the first panel. Dans la salle, nous...
In the room, we have Yves Gratton with Montreal and Laval Legal Assistance. Welcome.
Society. We have two attorneys from British Columbia, Naomi Moses and Caitlin Shane. Welcome to the committee. Can you hear me?
Yes, we can. Thank you.
Yes. Perfect. So because we try to do the witnesses on video conference first, in case, God forbid, we lose somebody, we're gonna start with your testimony, if that's okay. You have 8 minutes, but I won't cut you off till 10. And then we'll hear from Maître Gratton, and then we're gonna have questions. Please pivot. Please go ahead.
Thank you. Good afternoon, Honorable Chair and members of the committee. My name is Caitlin Shane, and I'm a lawyer with Pivot Legal Society. I'm joined today by Naomi Moses, who is a lawyer and one of Pivot's board members. Pivot is a human rights and legal advocacy organization based out of Vancouver's downtown east side. We take our mandate directly from our clients, who are sex workers, people who use drugs, people without homes, and people who by and large are living well below the poverty line. On behalf of our clients today, we urge the committee to support the proposed amendments to the victim surcharge provisions. It is critical to return discretion to judges who, under the current legislation, do not have the discretion to waive the fine for defendants who cannot pay. We do have some minor recommendations, and I will leave that to Naomi to discuss shortly. But by way of background, when Pivot intervened before the Supreme Court of Canada in a decision that challenged the constitutionality of the victim fine surcharge, we made the argument that the mandatory surcharge amounted to cruel and unusual punishment. And we explained what it means for a poor defendant to appear before the court and be imposed a fine that they will not be able to pay. And my hope today is to explain to the committee some of those harms that we explained then. So for the defendant who manages to pay the surcharge, it means having $100 less from the $335 that person earns on income assistance each month to pay for food and clothing and basic necessities. For the defendant who doesn't pay, it means being subject to civil enforcement. And in BC, the surcharge can be offset from social safety net funds, from bank accounts, and from wages. For the defendant who applies to extend the deadline for payment, a payment that this person may well never be able to pay, it means engaging repeatedly with an application process that is lengthy, that is inaccessible, and that is not supported by province-funded legal assistance. For the defendant who defaults on payment, it means living in fear of the constant consequences of default, which can include arrest. And it doesn't so much matter whether arrest is a likelihood. The Supreme Court of Canada has found, in relation to both sex workers and people who use drugs, that fear of arrest can lead to really dangerous consequences. It means being cut off from service providers. It means not calling police when there's an emergency and help is needed. And it means isolation amidst housing and opioid crises. And we submit that the surcharge applies to the same scenario. It's still relevant. A person who lives in fear of being imposed with imprisonment is subject to those same risks and will not necessarily rely on help when it's needed. So judges across BC have recognized these harms and, despite common law precedent, routinely sentence offenders to a day in jail in default of payment. And while this practice may be alarming, it is not rooted in malice. We say it's rooted in mercy and on recognition of the fact that this defender cannot pay, and there are no other options for the defendant who cannot pay. So I'll just close by saying that the Parliament today has an important opportunity to remedy the harms created by the mandatory victim fine surcharge. And we ask only that the provisions be made as accessible and as responsive to the needs of low-income communities as possible. And so I'll turn it over to Naomi now, who can better explain those. Thank you.
Good afternoon, Honorable Chair and members of the committee. I'm a lawyer at Rosenberg Kosakowski Litigation in Vancouver, and I'm here today on behalf of Pivot Legal Society. I echo my colleagues' acknowledgement that this proposed legislation is an important step in ameliorating the reality that Pivot's clients, many of whom live in extreme poverty in the downtown east side of Vancouver, have been very negatively impacted by the mandatory victim fine surcharge. We also have some concrete recommendations for improving these proposed amendments. I'll focus my submissions on only one part of the proposed amendments, that's section 737, subsection 5. As it is currently drafted, this provision allows offenders to be exempted from payment of the victim fine surcharge, provided that they can establish to the satisfaction of the court that it would cause them undue hardship. The individual must apply to the court for an exemption. We believe that the wording of subsection 5 should reflect what judges did in practice prior to the 2013 amendments to these provisions, which made the victim fine surcharge mandatory. The general practice in provincial court was for a judge to exempt a person, often on a judge's own initiative, during sentencing without a formal application, after the individual was given an opportunity to speak to their financial circumstances. Removing the words in this provision, an offender establishes to the satisfaction of the court that, and also on application of the offender, would restore judges' discretion to make these exemptions as needed, while retaining the presumption that a surcharge will be imposed. A revision such as this one would ensure that the hardship exemption is accessible to people who need it the most. These are people living in poverty, they are generally unrepresented by counsel, and they are often convicted of relatively minor offenses. For example, shoplifting groceries, breach of conditions, and failure to appear, all of which are very common criminal charges in the downtown east side. In addition, we urge the committee to consider how this bill might be expanded to waive the existing surcharges that have been imposed on people who cannot pay them. These are people who have already asked for extensions of time to pay, as this is the only relief currently granted under the existing legislation. We propose that this legislation be amended so that these surcharges are struck from the records of people living in poverty who cannot pay them without seriously compromising their well-being, their safety, and their survival. Thank you for the opportunity to speak to the committee today. We welcome your questions.
Thank you so much. On va passer ça maintenant à Legal Aid of.
Now we'll move to Legal Aid of Montreal, Maître Gratton. Thank you, ladies and gentlemen. I won't repeat everything we've just heard from the two lawyers from Pivot. I've also had an opportunity to hear their reasoning before the Supreme Court. A bit of background. I'm here because during a case in Quebec, I appealed because the discretion of the judges had been taken away by the Conservative Party in 2013. Their discretion to impose or not impose a fine that was heard by the Supreme Court in April 2018. We're still waiting for a ruling. 3 other cases from the Ontario Court of Appeal were combined with Mr. Boudreau's. There were 3 cases from the Ontario Court of Appeal, and the one I was working with Mr. Boudreau from the Quebec Court of Appeal. In brief, well, perhaps we are not going to say such things as breaches of Section 12 of the Charter of Rights and Freedoms. We're not going into that level of detail. The first thing that people have to understand is that we, as legal representatives of the accused, are not against the fine. It has a reason to be there, and it is important in the justice system. All stakeholders and all prosecutors in Canada agree. What we don't agree with is to take away the discretionary power of judges to exempt some people from that. What we would like to see is that discretion restored for such for the reasons indicated by my colleagues. In the criminal code, for example, when a judge imposes a fine on someone who is before him, the judge has to ensure that the accused, in fact, has the ability to pay that fine before sentencing him to or her to a fine. This should apply to this fine as well, because it applies not only to the cases we were mentioning, but if somebody is charged on 5 counts and a person is sentenced to jail, that fine will be set at $1,000, and that might appear disproportionate. Why? Because the judge will take no account of the fine that he is obliged to impose, that they are obliged to impose. At the end of the day, the offender will not pay. The offender won't pay because they have no money to pay. If there's no incarceration, community service is a possibility, but there's a time limit on that of 2 years in a province that provides that. So if you're sentenced to 3 years, how can you do community service in jail? I have no solution to that, but as far as I know, it's impossible for an inmate to carry out community service. So what ends up happening is that the jail term is extended. There are other applications, as my colleagues said, for example, when payment is in default. I understand that through courts of justice in Canada before 2013, there was not a stringent application on this of the fine, and it is possible that judges in criminal courts did not conduct the investigations they should have for the payment of a fine. I believe that lawyers and courts of justice have learned that since 2013 they have lost their discretionary power, and if that discretionary power were restored, the judges would be very careful about whom they imposed the fine on. It would not be imposed automatically. I think there had been a lack of stringency over the years, and the fine, well, we didn't consider it unimportant, but a lot of people who were sentenced were exempted from the fine when they should not have been. So a great many questions could and no doubt will be put, should and no doubt will be put, and I am certain that a great many defense attorneys will be seeing what the fine is imposed for and why. Thank you. I appreciate the testimony of all witnesses, and I will begin with the questions. Mr. Cooper.
Thank you to the witnesses. As I understand it, in 2000, there had been a change with the victim surcharge to provide judges with discretion in the case of undue hardship. Monsieur Gratton, you indicated in your testimony that it is your belief that the judges will be a lot more judicious in applying the waiver of a victim's surcharge in light of the fact that their discretion was taken away. I think it would be helpful for the record to understand, in part, and you did allude to it in your testimony, about some of the figures that we saw. In the province of New Brunswick, a report in 2008 indicated that the victim's surcharge in two-thirds of some 62,000 cases in that province had been waived. While judges were supposed to justify their decision for waiving the surcharge, this information was not included in 99% of 861 cases reviewed by that 2008 study in the province of New Brunswick. In light of really a consistent pattern of waiving the victim's surcharge, where there really, in many cases, was nothing other than the mere assertion that there was undue hardship involved, why should we have any confidence that this will be a considerable cost in the way of funds for services and programs to support victims as a result of that waiver?
Je comprends les préoccupations.
I understand the concerns that are raised, but respectfully, I do believe that the main question is not this. That's not the principal perspective from which we should tackle the problem. We should have confidence in the justice system, and I believe that those who are involved in it are both aware of what they need to do in the future and willing to do it. When judges lost their discretionary power in 2013, all the figures were provided to committees and to Parliament. I listened to much of the debate, and we can say what we like about the figures. I understand that there were some people who were exempted from the surcharge and who should not have been. So we can ask also whether when the surcharge is paid, does it actually go into the victim's fund? But that's not the real question. Will the judge and judges in general now be obliged to ask the questions they should ask? I believe so. Yes, I listened to the arguments put by my colleagues just now, and I believe that it is quite simple to see what someone's means are. When a person is on welfare, it's easy enough to ask, how much are you paying in rent and how much are you paying for food? And then when there's nothing left, I think it's clear enough for a judge to be able to make an enlightened decision regarding whether to waive the surcharge or not. I think that is what should be done rather than simply obliging courts to impose the surcharge.
For that, now, Monsieur Gratton and Ms. Moses and Ms. Shane, I certainly heard your testimony respecting the victim surcharge. All of you are lawyers, criminal lawyers. Do you have any comments on any other aspects of this bill, or do you prefer just to confine your remarks to the victim surcharge? I certainly welcome any other comments that you have as practitioners about some of the positives or some of the other concerns that you may or may not have with Bill C-75.
Premier. Je pense que la question s'adressait aux...
I think the question was really for my colleagues. No, the question rather was for all three of you, whether you had any comments on other provisions of the Act. I will answer, but I'd just like to clarify the question. Are we being asked whether we have comments on other provisions of the Act?
The short answer, yes. I'm asking if you have any other comments from your perspective as a practitioner?
Mais, en fait,
Well, the Supreme Court said that an indigent person could not be incarcerated for not paying fines or the surcharge. There is a provision, 734.7, in the Criminal Code, which states that at such time the person will once again come before the judge and should ask for an extension of the time needed to pay the surcharge. In Quebec, that period is provided for by the government. It's 45 days. But realistically speaking, yes, this is provided for in the Criminal Code. You go back before the judge, you ask for an extra 2 months, you don't pay the fine, you come back before the judge, you ask for an extra 2 months again, and so on and so forth. And a judge cannot require that an indigent person be incarcerated for non-payment of those fines. So in theory, that person will never go to jail, provided that the person applies for an extension each time. But in reality, people don't file an official application for extension. They're negligent. They don't do it. They don't know who to file it with, where to go, what to do. So people who are homeless, people who have no income, will not apply for an official extension in that way. And if a judge does not have an official application for extension, then the judge will issue an incarceration warrant. Once that warrant has been issued, it fulfills the goals of the surcharge. So I respectfully submit that in the end, Canadian society will have to pay for additional incarceration, longer incarceration for that person, and the surcharge will never be paid. That is one consequence. So theoretically, an extension can be requested before the judge, but in practical terms, there would be no reason to not to ask for an indefinite stay, for an indefinite extension of the time required to pay that fine. So what happens? A driver's license suspended because the surcharge is not paid. You can't apply for a pardon if you haven't paid your surcharge. And there are civil consequences as well, as there were with Mr. Boudreau. Mr. Boudreau had been released and he was asked to pay bail. He had deposited money with the court to guarantee that he would respect his release conditions. As the civil clerk of the Palais de Justice in Montreal simply used the money that he had deposited for his bail to pay the surcharge. So the person who had signed a bail bond lost their money. Thank you.
First of all, I'd like to thank the two witnesses who are here, couldn't be here in person, but are joining us from BC. Now, I guess the best manner to do this, because this opportunity was taken away from you, I was just wondering, as Mr. Cooper was saying, you were very, very persuasive on the victim fine surcharge and the harms that arise because of the system we previously had, and you're in favor of giving judges more discretion. But apart from that issue, is there any other aspect of this bill that is of interest to you that you would like to comment on?
I think for today we'll be limiting our submissions to those around the victim fine surcharge. I do note that I believe the committee will be hearing from Marie-Ève Sylvestre on some of the impacts of the bill with respect to sex workers as well as bail conditions. And I believe she's probably far better placed to speak to those. And I would say that her position on those issues would align with Pivot's as well.
Okay. So
Thank you.
No comments. Okay. From Monsieur Gratton, the question I had is, you were talking about how when it came to indigent individuals, There is a provisional in the criminal court that you can't necessarily force them to pay the surcharge. I would assume, and you said a lot of people are unaware of it, they're not exactly sure how they're supposed to take advantage of that provision. I would assume that would fall to duty counsel to inform individuals. Is that not generally the person who would guide individuals who perhaps cannot afford a lawyer? Would they not be their first line of defense to inform individuals of their rights?
Oui, absolument.
Yes, absolutely. The lawyer's role, in my view, is not limited to representing the client before the courts. And I'm sure that my colleagues agree with that. Our role is to inform our client of the surcharge amount, which is not stated in the court. The judges just say plus the victim surcharge. So the accused, in fact, has no idea of how much that surcharge actually amounts to. If the person has been released, the accused has been released, then we have to guide them over to the clerk so they can sign the papers. Once they have signed the papers involving the payment of a victim surcharge within 45 days, they know what they have to do. Are we supposed to phone them after 45 days to see if they've paid it? It's just as simple to say this person does not have the money to pay the surcharge, does not know where to turn to claim some kind of exemption. There's nothing in the papers that clearly states that the person has to go to a certain room or go to a certain judge and pay the surcharge. People who are homeless tend to lose papers. People who are substance abusers tend to lose papers. This is not just an excuse that they're making not to pay the surcharge, but that surcharge engenders complications that, in my view, were not intended by those who drafted the legislation.
Now, apart from the surcharge, is there any other aspect of this bill that you would like to comment on? Because all of your comments have been focused on that.
Non, c'est principalement.
No, I don't think so. It's just a section 737 of the Criminal Code that we're looking at today. I did not draft a brief. I would ask that if you wish to read my briefs to the Supreme Court, they are public, and I would invite you to look at them if you are interested. I believe that everybody will agree that the issue lies with the unintended consequences of paying the victim surcharge.
Mr. Stassi, do you have anything else?
Thank you. Nope.
Mr. Rankin.
Well, thank you. I'd like to thank all the witnesses. Merci beaucoup, Monsieur Gratton. I also particularly want to do a shout out to Ms. Shane and Ms. Moses. I've visited Pivot on a couple of occasions and seen the remarkable work you do for some of the most vulnerable people in Canada, and I'm simply in awe of what you do. So thank you for what you do, and thank you for testifying here today. I'd like to do a little bit more, though, about the nature of the case in which you intervened. I think you said that the primary argument was about cruel and unusual punishment for people who could not pay the fine, if I'm understanding you properly. The victim's fine surcharge was just simply impossible for them to address, and what I'm unclear about was the 1 day in jail in lieu of payment point that one of you made. I can't recall who, and I can't quite figure out how that connects up. So I'd appreciate if you'd speak to that. I assume that you support entirely the amendments that are made in Bill C-75. You did say, however, that you had some proposed changes, if I understood at the outset. I'd like to know what they are as well, those proposed amendments, beyond simply supporting it.
Certainly. So I would note that in Naomi's portion of their submissions, they did note a number of recommendations, and if you'd like, Naomi can reiterate those.
I'd appreciate knowing them, and I guess it's our job, of course, if we accept what you're suggesting, is to try to reduce that to writing, to put that into legislative language, and so any help you can provide would be appreciated.
Certainly, and I'll also answer your question with respect to the day in jail following Naomi's comments, and thank you for the compliments as well. It's appreciated.
So our proposed changes to Section 737, subsection 5, are simply to remove the language that right now says an offender establishes to the satisfaction of the court that, and then the words on application of the offender. And what we see that as doing is restoring the previous discretion that judges had in practice, and this is what they did in practice in provincial court, which was to speak with an offender at the conclusion of sentencing about the victim surcharge, give the offender an opportunity to speak to their financial circumstances, because we know that for many of these individuals, particularly the clients that Pivot serves, they typically are unrepresented, and they may not even have access to duty counsel. And because the victim surcharge occurs at the very end of sentencing, in practical terms, it's very difficult for these individuals to make a formal application to the court and then to satisfy the burden of establishing to the satisfaction of the court that undue hardship exists.
So the effect of adding the effect of adding that those changes would be to essentially codify the discretion that a judge would have in each and every case. That's the goal.
That's correct.
Yeah. Thank you.
While retaining the presumption that the surcharge will be ordered unless a judge exercises that discretion and the person before them provides some indication that undue hardship exists.
And you take no issue with that presumption. You're okay with that?
Yes. Pivot absolutely supports the importance of victim services and the importance of funding those services properly. Many of the people that Pivot serves are not just people who find themselves before the court as defendants, but some of them have also themselves been victims of crime. And so this is an important presumption that exists in the code, and we have no objection to the existence of the surcharge itself.
Ms. Shane, you were going to add something?
Certainly, you had raised a question about the practice in BC that is commonplace around sentencing an offender to a day in jail in default payment. And in our submissions as interveners, we actually appended a list of over 100 cases in BC in which a sentencing judge ordered for a surcharge to be payable forthwith, and then in default of payment, ordered that person to be sentenced to a day in jail. And I do want to be very clear that in raising this issue, I'm not in any way attempting to vilify BC judges. Quite the opposite. We are acknowledging that this legislation as it stands puts BC judges in an untenable position where they are faced with a defendant who they know cannot pay, and there are no other reasonable or proportionate means by which to sentence that person. And so it really is, we called it in our factum, an act of mercy rather than malice.
However, if you put a person who's a drug, I mean, I respect that you're saying that, and I understand the motivation, but if you're a drug user and you are in jail for a day, that could itself be very, very difficult for a person. But your point is the judge has no discretion at present, so that's the best you can do, and the BC judges have showed mercy. That will, of course, change with the amendments if they go through in Bill C-75.
Absolutely, and it's in recognition of all of those harms that I outlined in terms of balancing the different possibilities that, unfortunately, is in some ways the least of all evils. Thank you.
Do you have a short one that you want to continue with, Mr. Eichen?
No, it's okay.
Sure?
I'm out of time?
You're out of time.
Okay, thank you.
Ms. Khalid?
Thank you, Chair. Chair, I'll be handing over about a minute of my time to Mr. Sikand, if that's okay. Thank you to the witnesses for your great testimony. If I can ask Pivot, Ms. Shane and Ms. Moses, just taking a step back, objective of, in your opinion, of having a victim surcharge? Why is this in place at all?
Well, the objective as we see it is to fund services for victims, and those are very important services that warrant funding. Our objection is not to the existence of the surcharge or to the funding of those programs, but rather to the mandatory imposition of the surcharge on people who cannot pay it. It's simply an impossibility to ask someone who has only $335 a month from income assistance to pay a surcharge that in many cases represents 2/3 of their monthly income. And so while the objective of the legislation is laudable, and we think that the objective is frequently served by people who are able to pay the surcharge, is not served in the example of Pivot's clients and people who are similarly struggling just for basic survival. That objective is not served at all in those cases.
Do you think that the legislative changes as they stand in Bill C-75 do in some ways help in providing those services to victims? Is the money coming in, basically?
We think that the money is coming in. We need to be cautious in talking about revenue and the way that revenue comes in, because we can't actually assume that all of the surcharges that imposed will or could ever be paid. It's simply not possible. I note that in the last series of amendments in 2013, the amounts of the surcharges were doubled. And so for every person who's brought before the court convicted of a crime, they are now paying twice what they were paying before. And so even if many of those individuals cannot pay, the people who do pay are paying twice as much. And in many provinces, they have seen increases. But again, it's very difficult to track exactly what that increase in revenue is coming from, whether it's a result of doubling, whether it's the result of enforcement. It's very difficult to track that data.
So I from my understanding of your testimony, you want to make it more fair and not all-encompassing to those that are more vulnerable, that are in the justice system, that it would be unfair for them to have to pay these surcharges, and that there should be more discretion allowed to the judge to be able to make that differentiation. Am I correct?
That's correct. Yes, the legislation as it's currently written offers no discretion whatsoever. So we are advocating simply for the restoration of that discretion that previously existed.
Thank you. Mr. Gratton, do you have any input on the proposed amendments as they've been proposed by Pivot to the current C-75?
Non, absolument pas. J'ai rien à ajouter.
No, I have nothing to add to what my colleagues have said. Just to clarify a point regarding the question by Mr. Rankin a few moments ago, when my colleague was talking about a one-day imprisonment for failure to pay the surcharge. Judges don't do that in Quebec because the Quebec Court of Appeal has deemed that illegal, stating that judges must provide the statutory extension provided for by the province. They could not even set the time to pay the fine to 0. It is clear that when judges are have an indigent person before that, an image is worth 1,000 words. They know that they will never be able to pay the fine, so perhaps they sentence them to a day's imprisonment simply because they know that they will never be able to pay the fine. The judges know that person will never be able to pay the fine. I have, therefore, nothing to add to Mr. Rankin's question. I believe that it is crucial that judges discretionary power to waive the victim surcharge be restored.
Go ahead.
Thank you. My question is also for Pivot. I'm going to deviate a bit, but based on your testimony, I wanted to ask if I could get your comment on the intersection of your clients with the court. So more specifically, re-victimization and how that affects those that you represent.
Certainly, and it's somewhat ironic in the fact that we're talking about a victim fine surcharge designed to provide funding and protection to victims of crime, and so often our clients and other low-income folks across Canada who are engaged in oftentimes petty crime, breaches of bail conditions, simple possession of illicit substances. I don't mean in any way to sort of belittle or quite frankly victimize those people, because they are incredibly strong and resilient. But this type of legislation in which a judge cannot take into account the lived reality of a person before them is in and of itself quite frankly victimizing. And certainly the sort of laundry list of possible outcomes that I discussed, whether it's a person giving up a third or 2/3 of their paltry income assistance, or a person living in constant fear of arrest, that is sort of a picture of the law being used to victimize people further. And so, again, we really do push for the discretion of judges to account for what people are experiencing on a daily basis, because these are folks who are criminalized by their very existence.
Thank you so much. Mr. Rankin asked for a small bit of time
Juste
to
une
ask a
petite
small
question de
supplementary.
clarification pour Maître.
Just a brief clarification question for Maître Gratton. On the Boudreau case, what were the main arguments? Were they based on the cruel and unusual punishment principle? Principally, yes, because judges had lost their discretionary power to waive the victim surcharge. And from that, there had been instances where that surcharge could constitute cruel and unusual punishment and therefore be in violation of the Charter. I would like to thank Maître Gratton.
Your testimony was very helpful. Really, really appreciate it. And especially, I know it's hard by video conference. You can't see the people in the room. You can't see their reaction. But again, I thank you for what your organization does. Much appreciated. Et merci aussi, Maître Gratton. C'est bien, vraiment apprécié. I'd like
Thank you, Mr. Gratton. We've appreciated your testimony.
it a little bit early if possible, because we have a vote and we've got to get out at 5:30, and I want to make sure we hear from you in its entirety. And it is a great pleasure to reconvene this meeting as we are now going to hear from our second panel on Bill C-75. And I would like to welcome our witnesses for this panel, an esteemed group. We start with Mr. Steve Coughlin, who is a professor at the Schulich School of Law at Dalhousie. Welcome. We have, as representatives of gay and lesbian historians, we have Mr. Tom Hooper, who is at the Faculty of Law and Society program at York University. Welcome. And Mr. Gary Kinsman, who is a professor emeritus of sociology at Laurentian University. Welcome. And then from the Canadian Centre for Gender and Sexual Diversity, we have Ms. Calla Barnett, who is the board president. Welcome. And then we will be having with us, although he has not joined us yet, from Egal Canada Human Rights Trust, Mr. Robert Leckie, who is, he's just joined us. We have Robert Leckie, who is a law professor at McGill University, and in fact the dean at McGill Law, and a past president of Egal Canada. Welcome, Robert. I cannot hear you. Let's try that again.
Thank you very much.
Perfect, we got you. And as I was telling the other panelists, we always go with the video conference folks first, because in case we lose you, we don't want to lose your statements. So if you're ready, I know you just walked into the studio. I'm going over to you. You've got 8 minutes, but I won't cut you off before 10. And the floor is yours, Dean Leckie.
Great, thank you very much. And signal if I'm going too fast at any point, okay?
Mm-hmm.
Our LGBTQI2S communities are appreciative of the interest shown us by the federal government in a whole range of ways, reaching right up to the Prime Minister. In my time this afternoon, I intend to make 4 points. The first, articulate our general perspective or approach. Second, express Egal Canada's agreement with the submission by Gentile, Hooper, Kinsman, and Maynard, whom you'll be hearing from, it turns out, after me. I want to call for legislative change in 2 respects. The first is the failure in Bill C-75 to address the problem of surgeries on intersex children. And the second is a problem in the otherwise welcome efforts to undo past discrimination against our communities. So let me start just briefly with the overall perspective. We come at these issues at Egal Canada from a general approach attuned to LGBTQI2S equality, dignity, and inclusion. Fundamentally, we're keenly conscious of the long history of the criminal law's sexual and moral offenses being applied against our communities discriminatorily, discretionarily, and disproportionately. We would emphasize intersectionality, conscious that members of our community experience overlapping disadvantage in virtue, for example, of being queer people with disabilities or being racialized or Indigenous trans people. And I would emphasize the symbolic significance of the criminal law on matters touching our communities. So the Victorian prohibitions relating to sodomy, body houses, indecency, you name it, have consequences beyond their enforcement and convictions obtained. The mere threat of their enforcement can operate powerfully, and it operates more powerfully against those most vulnerable people who might not get good legal advice or have any idea how to respond. Second, very briefly, I just wanted to signal that we fully endorse the report from Kinsman et al. That you're about to hear from. We support their calls for Bill C-75 to go further than it does in a number of ways, and we affirm their call for adopting clear, evidence-based guidelines on the use of criminal law in prosecuting cases of HIV non-disclosure. Let me turn now to the 2 legislative changes that it's possible nobody else will raise with you. The first concerns intersex children. Subsection 268(1) of the Criminal Code sets out the crime of aggravated assault, and its subsection 3 addresses excision. It specifies that wounds or maims include cutting a person's labia majora, labia minora, or clitoris. But then it provides an exception where surgery is performed for the purpose of the person having normal reproductive functions or normal sexual appearance or function. And the alternative basis for the exemption from aggravated assault's application is when a person is at least 18 years of age. In other words, paragraph 268(3)(a) deflects the protections of the criminal law from children on whom surgery is inflicted for the purpose of giving them a normal sexual appearance or function. And the idea of the normal sexual appearance or function is a vehicle for cis-normative assumptions about which bodies are medically correct or normal. I can't undertake a full charter analysis this afternoon, but Section 268(3) raises concerns about security of the person and equality. Moreover, international human rights bodies have recognized that so-called corrective surgery of children whose genitals are characterized as abnormal violates their personal autonomy and integrity. So we urge you to amend Bill C-75 to modify 268(3). And the final point concerns to the legislation with a view to ending historical discrimination. So two corrective efforts, Section 156, proposed by Bill C-75, and the expungement mechanism in Bill C-66, already passed, rely unjustly and discriminatorily on today's age of sexual consent. First, proposed Section 156 preserves the possibility of prosecution for wrongful conduct where the offenses once in place have been repealed, so long as the conduct remains criminal today. And second, Section 25C of Bill C-66 provides for applications for expungement orders for convictions in respect of listed same-sex offenses on certain conditions, including that the persons participating in the activity were 16 years of age or older at the time. Now, both provisions aim to end the harmful effects of criminalizing same-sex conduct in a discriminatory way, while preserving the power to punish conduct that remains plainly criminal by today's standards. But both are problematic. Efforts to assure equal treatment must not rely, as these do, on the current age of consent of 16. Instead, it is necessary to take into account the fact that while the age of consent for sodomy was for a time 21 and then 18, the age of consent to different sex was 14 until the year 2008. Proposed Section 156 would still allow the prosecution for consensual sodomy committed with a 14 or 15-year-old, because today, someone that age cannot consent to sex, except with a person close in age to them. The expungement provision, for its part, would not permit the expungement of a sodomy conviction for consensual sodomy carried out with a 14 or 15-year-old. Whatever the good intentions, these provisions unintentionally perpetuate discrimination against our communities, insofar as there is no basis for prosecuting a heterosexual who had consensual vaginal intercourse with a 14 or 15-year-old while the age of consent was 14. Accordingly, Justice Canada's charter statement is incorrect when it states that the enactment of proposed Section 156 would limit any such prosecutions to those that do not raise charter concerns. Thanks for your attention.
Thank you very much. We will now move to Mr. Coughlin.
Thank you very much. I'm pleased to have been invited to speak with you today about the portions of Bill C-75 which deal with removing the outdated provisions in the Criminal Code, specifically those which have actually been struck down by courts as opposed to simply being out of step with the times. This is an issue that I've been concerned with for decades and about which I've been advocating with the Department of Justice for several years now. And we do seem to be on the verge of action being taken, finally, long overdue action. I'm, of course, in favor of that. And indeed, it's difficult to imagine any basis upon which anyone could be opposed to doing this. In September of 2016, a trial judge in Alberta, as all of you will know, convicted Travis Vader of murder, relying on the offense set out in Section 230 of the Criminal Code. Now, of course, Section 230 of the Criminal Code is part of the constructive murder provisions, and it was struck down by the Supreme Court of Canada 25 years ago. Unfortunately, despite its presence in the Criminal Code, it's not part of the criminal law of Canada. Now, this was exactly one of the flaws in the Criminal Code that a large group of criminal law academics pointed out to the Minister of Justice in a letter in December of 2015. And it was the same failure to update the code to remove constructive murder which led the British Columbia Court of Appeal to observe in a 2010 decision, "I cannot leave these reasons without wondering why steps have not been taken to amend the criminal code to conform to the now 20-year-old decision of the Supreme Court of Canada in Martineau determining that language in 229C is unconstitutional. The law that is recorded in the statute, on which every citizen is entitled to rely, is not the law of the land. An issue such as arose in this case should not occur. It creates the risk of a miscarriage of justice and the potential need to incur significant costs addressing an error in an appellate court with the possible costs of a new trial, assuming one is practical. In my view, failure to deal appropriately with such matters by updating the criminal code to remove provisions that have been found to offend the Constitution is not in the interests of justice." Now, as I say, that's a 2010 decision called Townsend. They reached that conclusion by citing other judgments in which exactly the same thing had happened, ranging from 1997 on to 2008, in which juries had been told that the law around murder was what was set out in the criminal code, when, of course, it's not. Now, I mean, that seems like a glaringly obvious point, but it's worth stressing it. Section 19 of the Criminal Code says that ignorance of the law is no excuse. We rely on that fiction that every member of the public actually knows the law, but that's really only justifiable if it's possible for a person to find out the law. One of the key principles of fundamental justice guaranteed by Section 7 of the Charter is the principle of legality, the notion that the law must be knowable. It's why we have the strict construction rule of statutory interpretation. It's why Section 9 of the Criminal Code abolished common law crime. It's the reason that laws can be struck down for being vague. If it's not clear enough what the law is, we say, then the law is unconstitutional. So we have all sorts of fundamental and important rules insisting on the language of the criminal code being as clear as it can possibly be. And yet, in that context, we have provisions which unambiguously state as the law what is unambiguously not the law, and we allow that to continue for decades. That is, frankly, dumbfounding. The trial judge in the Vader case received a certain amount of criticism, and at some level that's understandable. We expect judges to know the law more than ordinary people do. But the general public, they don't have access to annotated criminal codes. The general public, they're going to go online. They're going to go to the Department of Justice website, the official Government of Canada website. They're going to look up the criminal code, and it's going to lie to them about what the law is. And, of course, it's not just the general public. It's the police. The police should be able to look at a statute that accurately reflects the law of Canada. When that's not the case, then, of course, we get the situation that we have faced in Canada with dozens of people criminally charged with an offense which does not exist, the prohibition on anal intercourse in Section 159. Now, of course, such charges are eventually thrown out, but that's of very little solace to the person who has been caused the embarrassment and expense of going through that procedure. We can say, well, you know, the police should have known better than to believe that the criminal law was what the criminal code said it was, but that hardly seems like an answer. Let's think again about the blame given to the judge in the Vader case in not knowing that Section 230 had been struck down. Okay, yes, he should have known. On the other hand, all it means is that he failed to evade a trap which had been set for him. surely a legitimate question to ask is why we're setting traps for our judges. If someone falls because they don't notice that their shoelaces have been tied together, a lot of the blame has to go to the person who tied the shoelaces together. If a judge doesn't notice a trap which was set in the law, a good part of the blame has to go to the person who set the trap. In this case, that's Parliament. It's you. There's no good reason that this situation should have been allowed to continue for decades, but Parliament has allowed it to do so. How much work would it have taken to avoid the pitfall that arose in the Vader case and the ones that can potentially arise from the other unconstitutional provisions? Realistically, a summer student in the Department of Justice spending 2 hours some afternoon could have headed this off. And it's hard to see how drafting or passing such a bill could have occupied any real legislative time, since the Supreme Court of Canada has already done all of the policy work of deciding that the provisions are unconstitutional. Now, it's fair to respond that not every situation is the same. When the constructive murder provisions were struck down, it was clear that nothing needed to be put in their place. When loitering in Section 179(1)B was struck down, well, the Supreme Court provided some guidance as to what a constitutional law would look like. So you'd need a little bit of time to draft a new bill that was constitutional. When the abortion provisions were struck down in 1988, well, the Supreme Court didn't actually say no abortion provisions could exist, just that these ones were no good. So yes, some time might have been needed to decide, well, shall we do something else instead, and if so, what? The key point to note here, though, is that that only means that the second step might vary. The first step, invariably, is unchanging and utterly non-discretionary. The existing law is no law, and it has to be removed from the code. Whatever might happen after that, there's no reason not to do that in the short term. Which leads, I have to say, to my major concern here today. As I've said, there is no conceivable reason not to finally, after decades, remove these unconstitutional provisions from the criminal code. But we nonetheless seem to be faced with the real possibility that this Parliament will not do it. The provisions dealing with the removal of unconstitutional provisions used to be in their own bill. They used to be Bill C-39. For some reason, that bill, which contained nothing else and had no real possibility of attracting any controversy, those sensible and uncontentious provisions have now been placed in Bill C-75, which contains many sensible and many contentious provisions. Personally, I think that some of those other proposals are very good, and some, I think, have just not been thought through. And so it's difficult to tell, actually, whether they're wise or unwise. And all that's happened, and this bill needs to be thoroughly debated and passed through both houses with barely a year left until the next election. It won't be surprising if that doesn't happen. So that means that we're faced here with the choice between rushing through potentially far-reaching reforms without adequate consideration as the price for solving a long-standing and fundamental problem, or allowing that long-standing and fundamental problem to continue as the price for not creating further and bigger ones. That's not an easy choice, and it is not in the least apparent why we should have been forced to it, or why Bill C-39 couldn't have been proceeded with on its own. Ultimately, I do commend to you the portions of Bill C-75 which do the sensible thing of removing these unconstitutional provisions, and I hope that there's some fashion in which that can happen, whether the rest of this bill goes forward or not. Thank you.
Thank you very much, Mr. Hooper and Mr. Kinsman.
Thank you for inviting us to speak here today. I'll be sharing my time with Professor Kinsman. We are here representing a group of gay and lesbian historians with expertise in the policing of queer sexualities. We're here to follow up on the 10th report of the Senate Human Rights Committee, which called on this government to address archaic laws used to criminalize LGBTQ2 people in Canada. And I really mean archaic, like indecent acts, vagrancy, body houses. This is like the Antiques Roadshow of the criminal code. Bill C-75 repeals Section 159, anal intercourse, and this is an important part of the Prime Minister's recent apology to LGBTQ2 people, in which he specifically referenced the criminal provision against buggery and the harm caused by it. Acknowledging this harm the government passed Bill C-66, which allows those convicted of this offense to apply to have their records expunged under certain conditions. The repeal of anal intercourse is part of the larger effort to eliminate what has been labeled zombie laws. Now, these laws are still on the books despite court rulings specifically declaring them unconstitutional. The Prime Minister also apologized to those arrested in the bathhouse raids, and he specifically referenced the injustice caused by the Body House Law. But this was excluded both from Bill C-66 and the bill before us today. This is because the Body House Law does not precisely fit the government's narrow definition of a zombie law. It has not explicitly been declared unconstitutional by the courts. It's not a zombie law, it's a different kind of monster. It's a Frankenstein law. Now, why am I using this broad cultural reference to Frankenstein to describe the Body House Law? Well, I'm going to give you 3 reasons. First, like Frankenstein, the Body House Law is a 19th century relic. It was included in the original 1892 Criminal Code as a prohibition against brothels and other spaces of sex work. And it was amended in 1917 to include places of indecency in an effort to close massage parlors. This law is anachronistic and it must be repealed. Now, the second reason I'm calling this a Frankenstein law is that, like Frankenstein's monster, the Body House Law is known to cause harm. In the 2013 Bedford decision, the Supreme Court found the Body House Law to cause harm to sex workers that is grossly disproportionate to the objectives of the law. As a result, the reference to prostitution was removed from the Body House Law under the Protection of Communities and Exploited Persons Act in 2015, PSEPA. But PSEPA maintained many unjust laws, including the Body House Law and its reference to indecency, which was used by police to raid bathhouses. From 1968 to 2004, more than 1,300 men were charged in bathhouse raids, all under this law. Now, you heard last week how this caused harm to gay men like Ron Rosnes, a member of the Order of Canada, who to this day has a police record from being charged in the 1981 Toronto bathhouse raids. The government has specifically apologized for this unjust law. Why do we need to be here to ask for its repeal? Men like Ron Rosnes deserve to have their records cleared. Now, the third reason I'm calling this a Frankenstein law is that, like Frankenstein's monster, the Body House Law does not resemble the intention of its creator. This law was created by Parliament to criminalize brothels and other sexual spaces based on a community standard of morality. The 2013 Bedford decision led to the removal of sex work from this law. This left behind the vague concept of indecency, which was significantly altered by the Supreme Court in the 2005 LeBay case. In that decision, the law was not declared unconstitutional. Instead, it was rewritten by the court. The definition of indecency was changed from a community standard of morality to a standard based on non-consensual harm. This new definition of a body house is a very serious offense and is totally unrecognizable to what Parliament intended. What was once a morality law against brothels has turned into a heinous, violent crime. What type of establishment would allow such acts of non-consensual harm? And is a 19th century morality law the best tool to combat such places? Such acts are covered under other, more appropriate sections of the code. And it's strange that Section 75 of Bill C-75 amends the Body House Law to allow the possibility of summary conviction, a lesser penalty. This is inconsistent with the now gravity of this offense as the courts have defined it. In 1982, then Minister of Justice Jean Chrétien said to this committee, "As a matter of principle, I believe that if sections of the criminal code have fallen into disuse or become obsolete, there was no reason to maintain them." There were 0 charges under the Body House Law in 2017. Parliament does not need to wait for the courts to repeal this outdated law, especially a law that the Prime Minister has apologized for. I urge this committee to not only repeal the zombie laws, but also the Frankenstein laws and all other laws crafted in 19th century morality that have criminalized LGBTQ people and sex workers. Thank you.
Thanks, Tom. Also, thanks to Dean Lucky for the support from Miguel for the position that we're putting forward today before this committee. The act of indecency section of the Body House Law is linked to a broader legal construction of same-gender sex as indecent in Canadian history. This is also the case with the indecent acts offence. These sections have been and continue to be used to define LGBTQ2S practices as more indecent than similar heterosexual activities, mobilizing discriminatory practices against our communities. In this presentation, I'm drawing on extensive research and writing that I've done along with other members of our group on the regulation and policing of consensual sexual activities in Canada. Since the late 19th century, the offence of indecent acts has been used to arrest LGBTQ2S people in bars, clubs, parks, and washrooms. In these situations, the individuals involved have constructed relationships of privacy and intimacy for themselves, hidden from view behind trees or bushes and in cubicles with locked or closed doors, and have not been trying to bother other people. Often they have been entrapped by the police invading their privacy. Police often used indecent acts instead of gross indecency or buggery charges because it was a lesser offence and it was easier to prove in court. In the Purge campaign, the National Security Purge campaign that the Prime Minister apologized for against LGBTQ2S people, this was the charge, indecent act was the charge that the RCMP threatened to use to get gay and bisexual men to give up the names of their friends in the public service and the military so they them could purge those individuals. In Ontario, following the mass resistance to the bath raids in the early 1980s, the police used targeted surveillance, and this included the use of video surveillance equipment and indecent act arrests. These occurred in St. Catharines, Welland, Oakville, Oshawa, Mississauga, Guelph, Kitchener-Waterloo, and at the Orillia Opera House. The names of those charged were released by the police to the newspapers, leading a man in St. Catharines to kill himself. According to the Right to Privacy Committee, in Toronto, 369 men were arrested for indecent acts with other men just between July 1982 and April 1983. Thousands of people were unjustly arrested under the indecent acts offence. Section 60 of Bill C-75 amends parts of the indecent acts provision. This provision must be entirely repealed. This would also allow those unjustly convicted under indecent acts to apply for expungement of their conviction, which they are currently denied under Bill C-66. It is not listed in that bill, and it is still on the books. This committee can actually make an effort to deal with this historically unjust offence. Vagrancy is also a broad, ill-defined offence. It has historically been used against sex workers, but also to police people's gender and sexual expression. Those viewed as wearing the clothes and or otherwise engaging in the self-presentation of the wrong gender were charged under this offence. In a 1994 Supreme Court case, vagrancy was declared unconstitutional and contrary to the Charter. Section 62 of Bill C-75 removes part of the vagrancy law, but like body houses and indecent acts, the offence otherwise remains intact. It must be entirely repealed. The targeted use of morality provisions and police entrapment have created historic links and ties between the struggles of LGBTQ2S communities and sex workers. We fully support the position that was presented to you by the Canadian Alliance for Sex Work Law Reform. In 2015, the Justice Minister declared, "I definitely am committed to reviewing the prostitution laws." 3 years later, it is past time to act. In the broader context of repealing laws criminalizing sex work, we join the call for the repeal of the material benefits and advertising offences which create unsafe working and living conditions for sex workers and put sex workers at risk. There are many other laws that have been used to criminalize the consensual activities of LGBTQ2S people that must be addressed, but are not mentioned in Bill C-75. We certainly hope they will be acted upon soon. These include obscenity laws that have been used against LGBT bookstores and publications, and to construct non-conforming sexual representations as more obscene and more indecent than similar heterosexual ones. We also fully support the concerns that the Canadian AIDS HIV Legal Network and many others have raised regarding the sections of the Criminal Code being used to unjustly criminalize those living with HIV. In conclusion, we urge you to end the reliance of the Criminal Code on enforcing morality. This is done through various sections that define our sexualities as indecent and criminal. Instead, criminal offenses should be directed where they really need to be, which is on actual violence and actual harassment. The apology process to our communities demands that the Body House Law's indecent act and vagrancy provisions are entirely repealed in Bill C-75. Otherwise, that apology remains flawed and unfulfilled. You have the opportunity to fix this now. We hope you will take it. Thanks.
Thank you very much. Ms. Barnett.
Thank you. I appreciate the space that's being provided to me and to the Centre today to have our voices heard and to speak for those who cannot. I'm here for them and for myself and for all Canadians who value justice and equality. We're here in solidarity with the LGBT historians, and we fully support the points raised by Egal and Mr. Leckie. Before I begin, I would like to acknowledge that these proceedings are taking place on unceded Algonquin territory. As indicated by my colleagues today and last week, Bill C-75 is a wonderful opportunity for us to honor the apology made by the Prime Minister and address the continued criminalization of the LGBTQ2SIA community and the lack of bodily autonomy experienced by members of our community. That said, before I make my critiques and recommendations, I would like to offer my commendation for the inclusion of the repeal of anal intercourse as a crime. This repeal is a step forward, and the change is long overdue. Thank you. However, if we stop at this issue, this bill will become a lost opportunity for so many other overdue changes that would bring justice and equality to the LGBTQ2SIA community and all Canadians. We are everyone, and we are everywhere. The lack of repeal of the Body House Law, vagrancy, nudity, immoral theatrical performance, and indecent exhibition laws remains a serious point of contention between our community and the government. The apology delivered last year by the Prime Minister explicitly refers to the use of the Body House Law to criminalize LGBTQ2SIA community. However, no action has been taken on this issue. The effects of these laws continue to cause harm in our communities. The people who have been charged and convicted under them have lost their families, their loved ones, their careers. They live in precarious situations. Some have taken their lives. Those who are still with us cannot have their records erased until this law is repealed. They continue to live with the shame of such treatment. Some have for over 30 years. This state-caused harm has been acknowledged by the Prime Minister himself, and yet continues to be put aside. The criminalization of sex work has been ruled unconstitutional by the Supreme Court, specifically the 2013 Bedford case. Unfortunately, the PCEPA reconstituted a number of those crimes deemed unconstitutional, including communicating, obtaining sexual services for consideration, material benefit from sexual services and procuring, and advertising and material benefit and advertising, which work together to isolate sex workers. They cannot screen clients, hire security, or administrative support. Such laws continue to put sex workers in danger. Local, provincial, and federal police services continue to use this existing legislation to harass and criminalize folks who should be allowed to do their job with the support and protection of the state. We strongly recommend that a clear decriminalization of sex work be included in C-75. Bill C-75 fails to protect intersex children from non-consensual surgery. In June 2017, the CCGSD came out with our Pink Agenda, making it clear that we stand in solidarity with intersex communities and their right to decide what is best for their bodies. And yet today, Section 268(3) of the Criminal Code of Canada allows non-consensual surgery by medical professionals to alter the bodies of infants and children whom they perceive to be ambiguous, that is, intersex. In doing so, the bodily autonomy of those infants is removed by the state, the parents, and the medical practitioners who make these decisions and perform these surgeries. This causes undue harm because of their own discomfort. For example, Kimberly Mascott Zieselman, who published an opinion piece in USA Today in 2017, had her testes removed without her consent when she was 15. This surgery led her to take hormone replacements for the rest of her life, and she was not even informed that she had had this surgery until she was 41 years old. Imagine finding out that part of your body had been removed without your consent. Imagine that led to a continuing medical condition and medical expense for the rest of your life. That's what we allow with this law. We strongly recommend the repeal of Section 268(3) be included in C-75. Bill C-75 fails to limit the laws that allow the criminalization of HIV. We have been asking for clarity on this. To this day, and regardless of the government's own report, criminal justice system's response to the non-disclosure of HIV, which states that HIV transmission is a public health issue instead of a criminal issue. The non-disclosure of HIV is treated as an aggravated assault, sexual assault in the criminal justice system. In that same report, it is demonstrated that, and I quote, sexual activity with a person living with HIV who is taking treatment as prescribed and has maintained a suppressed viral load poses a negligible risk of transmission. The continued ability to criminalize the non-disclosure of HIV is in direct opposition to the government's own evidence-based report. Bill C-75 can be used to limit this law. It can be used to ensure that non-disclosure of HIV is not criminalized and that members of the LGBTQ2SIA community are not discriminated against by homophobic, transphobic, or otherwise rogue Crown attorneys. However, as it is written, it does not. Finally, my last point is that Bill C-75 fails to properly define marginalized person. While C-75 would require judges to consider the circumstances of an accused person from a marginalized group when deciding on bail conditions, the lack of definition of marginalized persons can be interpreted to exclude the LGBTQ2SIA community. We strongly recommend the explicit inclusion of LGBTQ2SIA in the definition of marginalized people in C-75. Thank you very much for listening.
Thank you very much for your testimony, and I appreciate it because a lot of the issues raised by this panel are new and ones that were not raised by previous witnesses, so that's very much appreciated. We're going to go to the first round of questions. Mr. Cooper?
Great. Thank you, Mr. Chair. And Professor Coghlan, I appreciate your submission with respect to zombie laws. And you did, of course, mention the case of Travis Vader, who murdered Lyle and Marie McCann, an elderly couple from my home community of St. Albert. Following Justice Thomas's decision under the leadership of our chair, this committee wrote a letter to the Minister of Justice calling on the government to introduce legislation to repeal zombie sections of the Criminal Code. Brett McCann, the son of Lyle and Marie McCann, shortly thereafter approached me, and he and I had a press conference along with his wife, Mary Ann, in St. Albert in December of 2016. And you're quite right. In March of 2017, the Minister of Justice did introduce Bill C-39, and then it sat at first reading. Nothing went forward. I asked the minister questions repeatedly about why the delay, why the holdup on a matter that is not controversial. As you pointed out, there is no conceivable reason why unconstitutional sections of the Criminal Code should remain in the Criminal Code there in black and white purporting to be the law. And as a result, we're faced with this situation now where some very straightforward bill, which could have been passed with basically on unanimity, is now tied in with a massive omnibus bill. And I can tell you that I am in touch with the McCann family, and they are quite distressed, and they have spoken out in deep frustration over the inability of this government to get it done. And I should note, you mentioned Section 159 of the Criminal Code respecting anal intercourse. Similar to the way the government handled Section 230, they introduced a standalone bill, Bill C-32, back in the fall of 2016. They made a big fuss about it, but it was such a priority of the government that it remained stuck at first reading. No action was taken on it. They then reintroduced the repeal of Section 159 with the introduction of C-39 on March 8th of 2017. Again, such a priority that it's stuck at first reading. And now we have Bill C-75. You are quite right. when you note that, it's not just this government, it's previous governments that didn't repeal unconstitutional sections. But I guess I would ask you, going forward, if we can hopefully get these sections repealed, what do you suggest occur so that this doesn't happen again? Because presumably this bill will pass and these sections will be removed, but inevitably there are going to be new sections that are going to be found unconstitutional. So what steps should Parliament take to be proactive going forward?
Sure. Well, I would note two things in that. One is it is worth observing that although the things that C39 would have done are duplicated in C75, C39 still exists. There is actually no reason C39 couldn't be proceeded with, even if C75 is not. On the go-forward basis, though, it seems to me that there's no good reason that the Department of Justice couldn't, every 2 years have the Charter Cleanup Bill. 2018 is what Bill C75 will be, but, why not the Charter Cleanup Bill 2020, the Charter Cleanup Bill 2022? It's just tiny little housekeeping tasks, and like any other housekeeping, you keep on top of it a little bit at a time, and it doesn't become overwhelming. So yes, it probably doesn't need to be done annually. It's not as though charter challenges are successful as often as that. But really, if biennially the Department of Justice simply looked at, okay, are there any of these basic administrative tasks that need to be done to the criminal code, and did that every 2 years, we'd stay on top of this.
And as we saw in the case of Travis Vader, the consequences of inaction are real. This is not some abstract academic issue. The McCann family waited 6 years for justice. And just as they thought that justice had finally arrived when Travis Vader was convicted of 2 counts of second-degree murder, literally that afternoon, they found out that, oh no, there may be a problem with that verdict. Just a few years earlier, it's my understanding that there was a case in British Columbia involving murder in which the trial judge left a zombie section of the criminal code, a copy of the section with a jury, the jury in the trial, and it was appealed to the British Columbia Court of Appeal, and the murder conviction was not overturned. It was upheld only on the basis of the trial judge's impeccable instructions to the jury. So what happened in the case of Justice Denny Thomas misapplying Section 230 is not the first time this has happened.
By no means, no. And I think the case you're referring to is Townsend, but at least 3 times that I know of, juries have, at the end of a murder trial, they've been going off to deliberate, and so they've made the perfectly reasonable request that they have a copy of the portions of the criminal code that are relevant, and someone has made the perfectly reasonable decision, yes, we'll give them a copy of the criminal code provision, and it's never occurred to them that the criminal code provision was unconstitutional and wasn't the law. It's staggering that that situation could be created. Not that the people in that moment should behave that way. That's perfectly understandable. What's staggering is that we should have created the conditions where that's possible.
Thank you.
Mr. Boissonneau?
Thank you very much, Chair, and thank you to all the witnesses for your passion and your advocacy. Professor Coghlan, I'm very much looking forward to getting rid of the zombie provisions, including Section 159 and others that you have mentioned. So thank you for your very lucid testimony on the subject. Kala, I wanted to just put on the record that this committee will be looking at an HIV overcriminalization study later this fall, as early as December, no later than early in 2019. It's something that I put on the committee, in front of the committee, and the committee accepted it. So that study's coming. So the question that I have for you, briefly, because I'm using my 7 minutes judiciously to get to all 4 of you, is why is it so important to list LGBTQ to people in the marginalized person provision?
Because it's not always visible that we are LGBTQ2 SIA. You can't see it on us. And so we would have to disclose to a judge in the first place. And doing so could put us at risk if we are not explicitly protected under the marginalized person definition. And so high-risk behavior that may have come to pass in an LGBT person as a result of that discrimination that they face by society may not be taken into consideration when it otherwise should be.
Thank you. Just for the record, is it true that when you use the acronym LGBTQ, SIA, you're referring to the lesbian, gay, bisexual, transgender, queer, two-spirit, intersex, and asexual populations?
Yes, that's correct.
Thank you very much. Dean Leckie, I want to talk with you about your comments about the intersex community in 268, Section 3A. Before I ask a pointed question to you, for colleagues on the Justice Committee, what we're talking about here are babies who are born with ambiguous genitals. They don't present as boys or girls. In the past, this would have been referred to as hermaphrodites. But the community has evolved, and people in the community use the term intersex. And this is a very important community. It's a marginalized community, and we have done work at the LGBTQ2 Secretariat to work with people like Dr. Morgan Holmes and others so that people can understand what happens. Imagine that you're parents and you have a baby and the baby presents ambiguous genitals. Medical professionals in this country can decide the sex of your child at birth, and they have a 50% chance of getting it wrong or 33% chance of getting it wrong, depending where that baby is on the gender spectrum. Friends of mine on Vancouver Island 15 years ago had a child with ambiguous genitals, and they found a medical professional who said, let the child grow up. This is exactly what the parents wanted. 2 months ago, that now 15-year-old had a gender reveal party and picked their gender. I'm not going to tell you what they picked because it doesn't freaking matter. What matters is that nobody poked and prodded at this 15-year-old teenager. And this teenager grew up to be a totally happy kid and has now chosen their gender. So we empower medical professionals to basically bring harm to babies. That's not cool. We should not allow that. So Professor Leckie, what language would you have in the section that would prevent this from happening?
Thank you for the question. Yeah, so I would keep perhaps the exception of an intervention for the health, but I don't think you need to keep for the purpose of having normal reproductive functions or normal sexual appearance or function. In the cases of intersex children, as I understand it, the surgery is not going to be able to generate reproductive capacity that the person does not have. And often the surgery is botched. It destroys, in fact, it can destroy the person's capacity for sexual pleasure and so on. So I think the whole idea that there's the normal appearance or sexual function and that that's the basis alone for intervention with nothing pressing medically, I would slice that away.
Thank you, and we'll look forward to a brief from you on this matter. Now, a question on another, that was a slight request to my friend and colleague, Dean Leckie. To both you, Dean Leckie, and to Professor Hooper and Professor Kinsman, should you wish, if the government could figure out a carve-out to body house provisions along a community standard that kept the non-consensual harm provisions, as it's been rewritten by the court, on the books, that would then permit us or allow us to have a schedule written up for cabinet that could then become part of the expungements legislation that would allow people like Ron Rosness and some 1,300 people that Mr. Kinsman and others have indicated have criminal records from 1968 to 2004 for having been arrested in body house laws. If the government could do that and attach that schedule to the expungements legislation, allowing those men to have their records repealed, would it then be fine, according to you, to leave the remnants of body house provisions as non-consensual harm offense on the books?
Maybe I could just say something quickly around that. Yep. I mean, the body house laws come from a historical period and continue to carry with them a certain type of enforcement of morality, right? There are problems that might exist in terms of the situations that you're describing. Those are much best and much better dealt with under provisions of the criminal code that actually deal with harm and violence and harassment. Those are what we really need to look for. I think historically and politically, it's absolutely crucial, if we're going to follow through on the apology from Justin Trudeau, that the body house laws be repealed in their entirety.
Dr. Leckie?
it also strikes me as problematic, like in the other offenses that have been repealed and you have the expungement mechanism, it's all instances, as I understand it, of the offense that could be expunged. What you're essentially proposing is that we'd have to look back to past convictions for being in a body house, running a body house, and you'd have to decide which ones were bad, inappropriate, Victorian, homophobic policing versus the ones that were permissible. So I think it would actually be complicated on the implementational side because it would not be a category of convictions. You'd have to be looking at the details of each one.
That's helpful. Professor Hooper?
Yeah, I think there's a principle that this law should not be there. I mean, what is the rationale or the justification for maintaining the body house law in its current form? It's not being used. So it's sitting there, and when I'm listening to Professor Coghlan, I'm hearing this idea that when you have laws that are in the criminal code, that's what they should actually mean. When you read the criminal code, that should be instructive to you as to what the law is.
It should be the law.
Right. So anybody here, go and read the body house law and tell me what it means. It's not going to mean what the LeBay case says it means.
I will be able to relate with my 15 and 17-year-old, and maybe even my 11-year-old niece and nephews after having talked about in Ottawa about zombies and Frankenstein today. So thank you all very much.
Well, can I just
quickly?
Sorry, I've got to get to Mr. Rankin next.
Sorry.
Mr. Rankin?
Well, I'll give you a chance to expand, Dr. Hooper. I just want to say for the record that I thought it was very, very good illustration of the importance of legal history that you're here today and you've told us about the history of these laws, which frankly I was unaware of. I find it entirely persuasive, and I will be moving before this committee for the repeal of the three sections that are addressed in the Bill C-75, namely vagrancy, indecent acts, and the body house provision. I totally accept your analysis. I think it can be handled if there are issues that remain through other sections of the code, or we can tailor it to suit what needs to be done in the 21st century. So I want to salute you for your use of history so effectively. Professor Coghlan, I loved your presentation. As Mr. Boissonneau said, I found it very, very lucid. I wonder while you're at it if you could get rid of the decimal points in the criminal code. Could that be part of the review? Because I can't remember. It's impossible to remember anything in the code. Maybe I'm dating myself, but that should be part of that task force, that law student that you've talked about in this summer. Could that be added to their job description?
Well, actually, I do have a response on that because I think it raises an important point. I mean, the reason that we now have sections like Section 487.011 sub B point 1 is because we amend the criminal code constantly, and of course we can't renumber everything. And I want to tie together your last point and that because I think there is a bigger issue here. On the one hand, I mean, I have found persuasive everything I've heard from my fellow panelists today and think, okay, yes, why is this not in here as well? But of course, normally when you've got a bill and you're thinking, why isn't it doing this? Well, it's because the bill's aimed at doing something else, right? Most bills are not aimed at doing everything that could possibly be done. But this bill actually is so big that it's a perfectly understandable reaction on anybody's part to think, well, you're already doing all of those unrelated things. Why don't you do this other thing, which would be a good thing as well? Which actually leads me to the bigger point. Why not just bite the bullet and undertake fundamental reform of the criminal code?
Right. Well, we used to have a law
We
reform
need
commission.
to do that. We've needed to do that for decades. Not just for minor things like this, not just because of laws which are out of step with the times, and not just because the interlineated numbers make it impossible to keep track of everything, but because we've needed fundamental reform of the criminal code. The Minister of Justice in 1979 said it's time to undertake a systematic review of the criminal code, and we still haven't done it. This is so close to doing that anyway. It's doing so many things. Let's just do it for real.
We call them omnibus bills. Things just sort of get conflated. They throw everything but the kitchen sink into it. We don't have a law reform commission anymore. There's no,
and we should.
As the federal government calls it, a responsibility center for just doing this cleanup work. British Columbia, and I'm sure other provinces, have what we call miscellaneous statutes amendment bills. Every year from A to Z, sections that are spent or been found to be unconstitutional are thrown in. They're passed unceremoniously at the last day of the session, routinely, no debate. I don't understand why we can't do that here today. I mean, I thought on the Travis Vader situation, Mr. Cooper gave a very thorough account of what that meant. I'd hate to be Justice Denny Thomas in making the error that he did because he had the temerity to rely on the written text of the criminal code. What a thing to have to be saddled with. I mean, I feel sympathy for him. You used the word dumbfounding. Hadn't heard that word before. I would use the word embarrassing, frankly, as a Canadian. Embarrassing we've let it get this far. So I thought, as Mr. Boissonneau said, your testimony was very lucid and compelling in this entire context.
Unanimous consent for the committee to proceed until we finish our round of questions?
Agreed.
Thank you.
I think I want to build on what Mr. Boissonneau asked you, Dean Leckie, if I could. I thought, pointed out, and of course you haven't done the thorough charter analysis that would be required, but I think you said very clearly you thought that Justice Canada's charter analysis, charter statement in respect of certain provisions was inadequate. Now, I think you were talking, I can't recall if that was with respect to Section 268 sub 3 sub A about intersex children and the protection, or were you talking about Section 25C of C66? I'm going to ask you to repeat that.
It was actually a third option. So the charter analysis
156
Justice was about proposed Section 156.
All right. Could you elaborate a little bit on that? I mean, I know you haven't done the analysis, but why would it be perhaps possibly non-charter compliant?
Right, because Section 156, the intention is to preserve the power to prosecute historical conduct that we still believe is reprehensible, right? So same-sex abuse of children by priests in orphanages, that kind of stuff, there's no attempt to make that out of the criminal law's reach when we repeal 159, right? The problem with 156 is that it relies on today's age of consent of 16 as the basis for deciding whether something can be expunged or not. And to me, it's unfair that in the past, when the age of consent for ordinary different sex intercourse was 14, it feels to me problematic that historically we're in a sense lowering the age of consent for anal intercourse, but only to 16. So that there is actually a group of people who had sex, an 18-year-old, 19-year-old having sex with a 14-year-old, and if they'd been a boy and a girl, that would have been perfectly legal. If it was two men, there's actually, if 156 passes as it's currently drafted, there's the potential that you could prosecute for sodomy or anal intercourse, because under today's law, a 14-year-old cannot consent to someone more than a couple of years older.
Thank you. I understand. Any time left, or am I finished?
You're finished, and I just want to make sure we get it in before the votes. Mr. Fraser.
Thanks. I'll be very brief because I know the bells are going, but I just want to thank all of the witnesses for appearing today. This has been a very interesting round, and I appreciate the presentations that have been made. Professor Coghlan, I really appreciate the thoughtful way you put forward your argument in a very sound way that made a lot of sense. I guess what I'd like to ask you is if there's going to be a possibility of having these every couple years sort of charter cleanup sort of bills that come forward, given the fact that sometimes court rulings impact on one part of a section or elements within a section of the criminal code, I would imagine that it would be wise to have some sort of consultation to ensure that it actually reflects the court ruling. You mentioned a law reform commission being necessary at the federal level to try to give some guidance perhaps to legislators when they're drafting that. But how else could you see any sort of consultation with the legal community for that sort of bill that cleans up our code as we go?
I mean, in an informal way, such lines of consultation exist now. As I mentioned, a large group of criminal law academics sent a letter to the Minister of Justice in December of 2015. And that has led to some informal collaboration on a number of things. We have provided the department and the Minister's office with the names of people who are interested in and expert in a number of different areas. And so I know, for example, you've heard from Marie-Ève Sylvestre on the bail issues, and she's one of the people on the expert lists around bail. So really, at that kind of informal level, those lines are there. There certainly would be no harm in something more formalized, though. I mean, personally, I am in favor of the notion of a law reform commission to have something on an ongoing basis. But the last time the criminal code was amended, which is embarrassingly before I was born, what was done was a royal commission was struck, right? A royal commission to amend the criminal code, and it conducted those kinds of consultations with affected communities, not just with academics, but of course with like the people themselves who are connected, either by, say, through Pivot Legal Society to get input from that community, or the kinds of organizations which are here as well here today. Of course, we want wide consultation, right? Not just with academics about this, but with the affected people.
Yeah, great, thanks, and I know my friend has a question.
And thanks for giving me the rest of your time, Mr. Fraser. I have 3 short questions, so short answers, please. Dean Leckie, on the Section 156 issue, can you explain is the issue for you that you're concerned that men today will be charged for acts before 2008 where they had sex, not benefiting from the close age exemption with men who are 14 or 15-year-olds, or are you concerned that their convictions for something they have been convicted for having sex with a 14 or 15-year-old before 2008 will not be expunged?
I mean, it's both. I think the chance of fresh charges being laid now is relatively remote. So I think it's more concrete in that it's a gap. The expungement provision, I don't think goes as far as it was intended to go in Bill C-66. But given that we know that the criminal law can be used, in ways we don't imagine, I think you should fix them both. But I think realistically, there's a real problem with the expungement.
Perfect. Mr. Hooper, Mr. Kinsman, question for you. Following Bedford and following LeBay, as I read the Body House provisions right now, the Body House provisions, as they are stated, are not at all what the judgment in LeBay actually says. So nobody would actually, on the plain reading of reading the Body House provisions, actually know what was illegal. Would you agree with that?
It's absolutely true, yeah.
Yeah, it uses language like acts of indecency, which are incredibly vague and have no concrete meaning at all.
And so following your reading of the current statute and following your reading of the decisions in your historical analysis, would you be able to confirm that there's absolutely no provision that is meant to be touched by the Body House provisions that is not covered by another provision of the criminal code that remains in existence for what the court in LeBay said that it should mean?
Yeah, I can't imagine. Okay, I don't know what type of place a Body House would look like in 2018. I don't know what it looks like, and I don't know if it ever has existed.
Perfect.
And just around that, if the problem was violence and harm, there are other sections of the criminal code that are much more appropriate to deal with that.
Perfect. Totally agree. Ms. Barnett and Dean Leckie, on the last issue that you raised of intersex, I completely understand the issues that you and Mr. Boissonnault presented. I just want to be reassured that the interpretation that you're giving in terms of doctors and parents making a sex selection at birth in no way would infringe upon, in the future, the rights of parents to circumcise their children for religious reasons or other things. You're not making the argument that parents should lose such a right, are you?
No, I'm not making that argument. And I don't think that it, in what Dean Leckie has indicated should be repealed, the language.
I agree. It's not covered under that. I just want to make sure that this is not an argument that we're now introducing, that it should be criminal to do a circumcision. Dean Leckie?
No, I don't think so. I mean, the basis for a circumcision being permitted today is not that it's producing a normal reproductive function or that it's giving a normal sexual appearance.
Perfect. So I really appreciate that, and thank you, colleagues, and thank you to this panel. We will be back for the next panel following the votes. Meeting in recess. Hello, colleagues. I want to apologize to our third panel of the day for being late. Votes in the House of Commons sometimes are things we can't control, but it is a pleasure to welcome our third panel of the day on Bill C-75. We're joined by Mr. Joel Hector, barrister and solicitor. Welcome. By the Canadian Association of Crown Counsel, represented by Mr. Rick Woodburn, who's the president. Welcome. And by video conference from Kelowna, British Columbia, from the Toronto Police Accountability Coalition, Mr. John Sewell. Welcome.
Hi, thank you.
Mr. Sewell, because you're on video conference, we're going to go with you first. You've got 8 minutes,
Perfect.
and I'm turning the floor over to you.
Thank you very much. Well, I'm in Kelowna because my wife and I are visiting friends in the interior of British Columbia. So although I'm usually in Toronto, today I'm in Kelowna, and weather out here is terrific. I'm the coordinator of the Toronto Police Accountability Coalition, which is an organization that's been around in Toronto since 2001. And our job is basically to try and propose progressive policies to the Toronto Police Board and the Toronto Police Force. And we've been dealing with lots of issues in the last 17 years. Some of the more recent ones are carding, how the police deal with those who are in mental crisis, the question of strip searches, racial profiling, police oversight, police training, and police recruitment. And TPAC has an electronic bulletin which is published bi-monthly for free, and it generally summarizes the kinds of things that are happening in Toronto and our thoughts about them. TPAC has submitted briefs to the Toronto Police Board in support of a policy requiring Crown attorneys to report to the board in cases where a judge has concluded that an officer was not telling the truth under oath. And that seems to happen 3 or more times a year in Toronto. And the board, of course, has now adopted such a policy. Our concern that we want to voice today is in regard to section 657.100 of the bill. This section permits police evidence to be entered by way of affidavit. And it says that affidavit evidence can be used for the presentation of routine police evidence. And I wanted to deal with some of the things that seem to be routine at the current time, at least in Toronto, and I suspect in other cities. One is the idea of carding, where police stop citizens at the whim of the officer who demand certain information of those stopped. Carding has been considered a routine of the police in Toronto and in Ontario until very recently, when the law has been changed. And we know that carding is basically done to black youth, and it's shown to involve racial discrimination. And we think it's unreasonable to suggest that evidence gained this way should be provided to the court by way of affidavit. Another routine police activity deals with arrests for the possession of marijuana. And this is also infected with racial discrimination. 3 times as many black people per capita as white people are arrested. And again, we think this is wrong and should not be allowed to happen by way of affidavit. Thirdly, strip searches in Toronto are considered routine. At least 40% of all those arrested for any crime in Toronto are strip searched. Even though the Supreme Court of Canada has declared in its decision in 2001 that such searches should be rare, which we interpret to be, well, maybe less than 10%. And as we know, that the fact that strip searches have been done in some cases are reasons for the judge to actually throw things out, throw charges out. The other point we'd like to mention is that there are instances, which I have mentioned already, where police evidence in court is challenged as being untruthful. And sometimes officers give evidence which they know is untrue, and the courts struggle to determine what the truth actually is. And often, courts have to come to this decision on the basis of the officer's demeanor, and that would not be available by way of affidavit evidence. We recognize that there are some cases where the police affidavit evidence may be challenged, but we aren't convinced that that's a good way to proceed, sort of after the fact. And we believe that, in fact, this section should be deleted from the bill. We do want to stress that we wish to support actions which shorten trials in order to save precious court time and resources. And this is an issue that, in fact, our organization has addressed. And we think that the way to proceed on that is by instituting pre-charge screening, where, in fact, Crown prosecutors sit with officers to determine what charges should proceed. This now happens in 3 provinces in Canada, British Columbia, Quebec, and New Brunswick. And in fact, there's been a very significant saving of time for courts because of pre-charge procedures. In Ontario, the courts, the charges that would actually proceed would be reduced from about 93,000 a year to 70,000 if pre-charge screening were in place and the same rules were adopted as in Quebec. And also, many fewer cases are stayed in courts or withdrawn. In Quebec, the number stayed or withdrawn, and that's where they have pre-charge screening, is 9%. In Ontario, it's 46%. So you want to save court time, forget about the affidavit evidence by officers, and instead proceed by way of pre-charge screening. So that is our submission, which is respectively given to the committee. Thank you very much.
Thank you very much, Mr. Sewell. We'll now move to Mr. Hector.
Thank you. Thanks for inviting me to make these submissions. These days it can feel sometimes a bit like the world's going to hell in a handbasket and there's nothing you can do about it. And I suspect each of you ran for office because you want to do something about it. You want to make things better for your families, just like I do. I'd be a terrible politician, but as a lawyer and a father, I'm here to try and help so that the Canada my son grows up in has the best possible system of criminal justice. And because I've only got a few minutes to address you in these opening submissions, please forgive my bluntness. There are a few good measures in C-75, but much of it, from where I sit, appears arbitrary. And I'm very concerned that if it passes in anything close to its current form, it'll do far more harm than good, which is really too bad. Because had this kind of consultation taken place, I have been looking at some of the evidence you guys have already heard, and I've read some of the briefs that have been submitted to the committee. Had this been the process before the bill was tabled, I suspect it would have come out quite differently. The government would have had the benefit of thoughtful submissions from criminal lawyers who spend their every day dealing with these issues. But now that it's past second reading, the government has poured a lot of political capital into it, and I worry that despite your commitment to do what is right, what I'm about to say may fall on deaf ears. But my principal recommendation is this: don't rush this. When you step back and take a look at this bill from a distance, a pattern emerges. C-75 gives greater discretion to police officers and Crown prosecutors, restricts the discretion available to accused persons and their representatives, and fails to restore the discretion that was taken away from judges by the Harper mandatory minimums. And on that last point, we all know that Senator Kim Pate managed to draft what I think is a fairly simple fix to the mandatory minimums several months ago in Bill S-251. You take out the preamble and the explanatory notes. That bill's 3 pages long, including both official languages. It's simple, elegant, drafted to stand the test of time. And as you know, your colleague. A week later, Sherry Benson, NDP member for Saskatoon West, proposed a similar solution with Bill C-407. But I was really disappointed to see that after nearly 3 years of studying this issue, the government has not tabled anything in this bill to deal with those mandatory minimums. And I say this with a bit of sadness, but respect. I submit that the government's actions may speak louder than the words they're using to describe this bill. But what does this action, this C-75, say? That a lot of trust is being reposed in police officers and crowns, which in certain circumstances is perfectly reasonable. But let's look at what that actually means. If the bill passes in its current form, officers will have a lot more discretion for dealing with breaches, for example. Permitting officers to give evidence in writing, which Mr. Sewell was just talking about, maybe without even being cross-examined, that is a breathtaking expression of trust. And for their part, crowns are going to be entrusted to decide what procedural protections are available to accused persons in a much wider scope of cases. And I'm not pulling this trust thing out of thin air. As Parliamentary Secretary, Mr. Mendicino, who's no longer part of this committee but was until recently, made it clear in the House that Bill C-75 is meant to increase the Crown's ability to exercise informed discretion on a case-by-case basis. That's one big reason why the government is hybridizing so many more offenses. He said that shortly after suggesting in the House of Commons on the same day, and this was June 5th of 2018 in response to a question from Elizabeth May about routine police evidence, that defense counsel suffer from bad judgment and quibble over immaterial things. Now, don't get me wrong, I'm not saying that Crown discretion is a bad thing. We know that Crown discretion is a key part of a properly functioning judicial system, criminal justice system. But as the Supreme Court made clear in a case called Bain back in 1992, basic rights cannot depend on the continuous exemplary conduct of the Crown. And that case, interestingly enough, was about peremptory challenges and stand-asides. At the time, the Crown had significantly more opportunities to affect jury composition than the defense. And the Supreme Court said that was inconsistent with 11D of the Charter. By contrast to all that additional discretion granted to agents of the state, Bill C-75 takes basic tools that my colleagues and I use to ensure that justice is done fairly, takes them away from us. Our role as a check against abuse is significantly constrained. And to be clear, abuse does sometimes happen. That's why in my brief, which I know you all got this morning, and so you may not have a chance to read, I recommend enacting a criminal provision prohibiting non-disclosure. And the justifications for this bill that I see in Hansard, they don't make a lot of sense in a free and democratic society. Take this idea of sparing witnesses from having to testify twice. If you take that to its logical conclusion, complainants would be spared even more if we moved straight from arrest to conviction without the need for a trial. We'd also save a lot of time and a lot of money. But that's not what a fair system of criminal justice does. And if we look south of the border, the United States Supreme Court talked about the need to ensure the integrity of the fact-finding process through things like appropriate cross-examination. And this is a case, Coy versus Iowa from 1988, the Supreme Court. While the process may unfortunately upset the truthful rape victim or abused child, by the same token, it may also confound and undo the false accuser or reveal the child coached by a malevolent adult. And the court concludes that passage by saying, it is a truism that constitutional protections have costs. Our system of criminal justice is not exactly the same as the Americans, nor should it be. But that quote, that case, says something universal. We don't have trials because they're convenient. They're not. Nor are they generally much fun for the people involved. They can be expensive, and in rare cases, they can take a long time. I can assure you, despite what you may have heard, the defense bar is not complacent about that. The overwhelming majority of accused persons want the whole process over as quickly as possible, but not at the cost of injustice. While cases with a preliminary inquiry often do take longer than those without, that's no reason to abolish most preliminary inquiries. It's simply a reflection of the fact that more complex cases tend to be the ones that require prelims to ensure that the subsequent trial is fair. Every Canadian accused of a crime, not just those facing a life sentence, rightly expects to have a fair trial. Perfection is always going to be unattainable, but procedures which support fair trials are critical to preventing wrongful convictions. In many Canadian criminal cases, a well-conducted prelim is what makes the subsequent trial fair. Cross-examination as of right is a cornerstone of fairness in free and democratic societies around the world. So I urge you to carefully consider the consequences of passing C-75 as is. It will take years of expensive litigation to undo the damage, during which time a number of innocent people will almost certainly lose liberty as a direct result of the bill. Fix it now, and you can prevent that. Thank you.
Thank you very much. Mr. Woodburn?
Well, good evening, everybody. And listen, I know it's going to spread around that I may have a flight. I'm not worried about that. The important thing here is that we get this right. All the questions, don't hold back on the questions, I guess what I'm saying. I'm Rick Woodburn. I'm the president of the Canadian Association of Crown Counsel. We represent approximately 7,500 Crown Counsel across the country from the 10 provinces and the federal government. This is both Crown attorneys and Crown Counsels. So a wide variety of input came into our submissions. I didn't file a brief. However, we have limited submissions that we'll have and take questions, of course, as need be. I'd like to thank the panel for inviting us. Appreciate that. And some of our comments may go against the grain a bit. I don't want to disparage anybody, the drafters of the legislation or anybody who worked diligently on this, but we would like to kind of delve into it a bit. Our role isn't going to be to I guess endorse or kind of go against the bill itself, but what we want to say is kind of give you the pros and cons, give you some information about what on-the-ground prosecutors are saying about this and Crown Counsel about this particular bill. And it's between Crown Counsel, of course, we're not universally in agreement with all the sections either. I mean, there's viewpoints from both sides, and I hope to get some of that out today, at least to give you the information so that you can perhaps go back and when you think about amendments and you think about the different sections, perhaps maybe some of these things will help for knowing what's going on the ground. First thing we'd like to look at is the bail reform. And particularly, we look at the change from 423 and 424 to the new now 423.1. So my understanding of the 423.1, it's inserted just before 424, so it takes up that entire section. We're not eliminating, from what I can see, 423, so there's still that opportunity for a Crown to make an application to have somebody's bail revoked. What this extra layer does in the Crown submission is just tacks on another, in some aspects, another administrative hearing to charges about charges of breaches and so forth. So when we look at it, it actually is repetitive in a lot of sense, and we all agree that we're trying to prevent delay here, and having a repetitive section in the criminal code won't necessarily help us. And here's what I mean. When we look at 423 as it is right now, the Crown has the discretion to do everything that 423.1 says. We can withdraw the charge. We can ask that the bail be revoked, and so forth. So we can already do that. And 423.1 presupposes that the Crowns aren't looking at the charges when they first come in and aren't assessing the strength of the Crown's case when they first come in, and we are. And it's important for us as Crown attorneys to ensure that these charges, these breaches of bail, are sufficiently looked after. It's just another layer in the Crown submission or in our submission that is not needed in reality. Because the Crowns are already doing their work, are already doing their jobs and vetting through this. The other thing which is interesting about administration of justice charges or breaches is that there seems to be a lot of talk about the amount of breaches that are in the system and how it's clogging up the system. And I can tell you from the ground, they don't clog up the system. They don't take that much time. A breach of a court order takes very little time to prove, even if it goes to trial, and that's rare. So they're not, keep in the back of your mind, these charges aren't clogging up the system. There's lots in the system, but they're not clogging the system. The other thing to remember about these charges, and when somebody breaches their court orders, it's important for everybody to realize that this is a cornerstone of our bail system. somebody has been released on bail, they're supposed to be following conditions, and they don't. So they're arrested and brought in. There has to be a penalty to this. And my understanding of 423.1 is actually, if it plays out, looks to be more of a slap on the wrist. And believe me, the criminals will realize fairly quickly that if there's this extra layer and they can use it, then there'll be more people breaching their court orders. That's a little bit about the bail reform, and of course we'll be open to questions later about that. Preliminary inquiries, when we look at the preliminary inquiries, a lot has been said. I've read some of the, or I've heard some of the testimony and read some of the briefs. It's very controversial about eliminating preliminary inquiries for non-life sentences. Once again, Crown attorneys have voiced opinions on both sides of this. And I kind of like to give you the pros and cons a little bit about that. First, the pros to getting rid of them. Yeah, one of the obvious and most glaring is sexual assault victims. And of course, having a sexual assault victim testify twice. I think even a panelist here, or not a panelist, but a witness has stated that it re-victimizes them. And I've seen it firsthand. So eliminating that, of course, will perhaps maybe bring back, I guess that's not a good way to say, but encourage people to come forward in sexual assault trials if they know they're only going to have to testify once. And of course, when we talk about testifying, that also includes children. For some reason, the bill doesn't include aggravated sexual assault. So in those cases, of course, there's a right to a preliminary inquiry. There are some issues from a Crown's perspective with regards to preliminary inquiries as they stand right now. Part of it is the focus hearings, or so-called focus hearings. And that's where the Crown and defense go before the court, and we tend to focus the issues at trial. What we're finding more often than not, they're not getting focused. We end up running what's called mini trials, and we're put to the test to prove our case under the Shepard test, of course. So that often the focus hearings that you hear about in the criminal code don't necessarily work the same way that they're being explained to you. The other part is putting forward our case by paper, or putting in the witness statements and putting that so forth. Different jurisdictions do this different ways, but what I'm hearing is that in most jurisdictions, courts aren't allowing and defense aren't agreeing to the Crown simply putting in a paper preliminary inquiry. So different jurisdictions do it differently, but we're finding that that's not really the case there. So when we're looking at eliminating preliminary inquiries, we see some of the issues that are attached and the pro side of it. The con side of it, of course, is it doesn't give an opportunity for the parties, not only Crown, but defense, to analyze the case, to see the witnesses, see how the evidence actually comes out. It also doesn't allow for, it doesn't allow for the Crown and defense to come to some sort of resolution after the preliminary inquiry. So those are some of the things that are missing when you're talking about that. So there's some pros and cons. We've heard some of those already, but I think it's important to keep those in mind. One of the other things, of course, is the peremptory trial challenges, and that's important. I've done probably 50-plus jury trials and been through many challenge of causes, and they last somewhere in the range to a day and a half, give or take, for a homicide trial. So it's a lengthy process as it is right now. And if you look at it, you go through your general exemptions, specifics, and then peremptory challenges, and sometimes a challenge for cause, depending on how that goes. I notice in the bill now in 638 and 640 that while peremptory challenges are eliminated, the challenge for cause section is actually still there. So if you look at it under 640 sub B, you'll see that there's room for defense counsel and Crown to raise issues regarding the impartiality of a juror. And juror, as it's been interpreted, means the jury panel. So when we have a challenge for cause, that's the section that's invoked. Now, if you look at it, the logical end to that is we're going to have challenge for causes in more cases, which take a great deal of time. So that's one issue. The other issue, of course, is that ultimately the judge is going to make the final decisions on each juror that's picked. So if you look at how this is going to actually play out, a challenge for cause is some questions are done up between Crown and defense and decided upon. Each juror is brought in and questioned. And how we envision this to kind of unfold is that the juror is brought in, they're asked the questions, defense and Crown are given an opportunity to speak to it, and then the judge is going to ultimately make a decision with regards to whether or not that juror is impartial or not. And that continues on until you have your 12 or 14 or 16 jurors, depending how it goes, which will make it a lot longer process. We're going to move from a day to 2 or 3 days, depending on how long it's going to take. So the way that we see that this envisioning is very problematic, because you've taken one issue and turned it into a bigger issue, in the Crown's, in our submission at least. But we can see how it logically comes out. And of course, the cases, the Supreme Court of Canada has stated that a judge should and shall stay out of those impartiality hearings. So them making a decision on the impartiality of a juror inserts them right into the picking of the jury itself. And that, the Supreme Court of Canada says, may be unconstitutional, which is where that part of the bill may end up after we run a couple jury trials. So we find that problematic. How are we doing for time?
You're about 12 minutes. You're past your time. So might as well try to wind it up if you can.
Hybridization of offenses, just two basic things we can say about that. One, obviously the 12 months for the summary offense is fine by us, I guess. The increase from 6 months to 2 years is not problematic because Crowns, in a sense, have to make a decision about whether or not somebody is going to get more than 6 months or less than 6 months when we're looking at a summary offense. We've been electing indictably in a lot more matters when we feel that, given the nature of the offense, the record of the accused, and other circumstances, that we have been having to go by indictment. So that's one of the issues that we've had. Now that it's gone up to 2 years, there's that kind of gray area where people who could be getting more than 6 months but less 2 years, we can actually elect summary. So that's the pro. The con of that, of course, is that you may see a lot more cases, more serious cases, and more cases in provincial court. Thank you very much for your time. Sorry I went over.
No problem. Thank you very much. So we're moving to questions. Mr. Cooper?
Thank you, Mr. Chair. I'll direct my first question to Mr. Sowell. You made reference to different types of routine police evidence. One of the issues with Bill C-75 is that routine police evidence is pretty broad as it's defined. It includes everything from observations to identifying or arresting an accused to the gathering of physical evidence. That doesn't sound to me like routine police evidence. That sounds like that could be the entire case in terms of evidence.
Yes, I don't disagree with that. I gave some examples of things that have been considered routine in Toronto, but in fact, it's a very, very broad definition. I think that's a problem. That's why the section should go.
Care to weigh in on that?
Yeah, I mean, not only is it overbroad, but it's problematic in that you guys and your colleagues in the House aren't psychic. It's impossible to know before a charge is laid or even a crime has been committed what's going to be important to cross-examine on at a trial. I routinely, as defense counsel, build the defense by cross-examining different police officers and figuring out what exactly it is that is important. I mean, I figured out in advance, but helping the judge or jury figure out exactly what is important. We as counsel, and I'm talking about Crown's and Defense Counsel, routinely put together agreed statements of fact, which I know you guys have already heard about, because sometimes issues aren't in dispute. And that tightens things up, and we all see that. And like I say, we're not complacent about delay. We want to see things move expeditiously as well. But to say in advance that any category of evidence is going to get a free pass from cross-examination, or that we have to apply to cross-examine a particular witness, which is unprecedented, really, in common law jurisdictions around the world, that you would have to, for the basic right to cross-examine, which is protected under the ICCPR, as I mentioned in my brief, that you would have to apply for that. It makes no sense. Should there be something that's truly trivial, it can go in an agreed statement. But you can't know here, now, with the greatest respect, because you guys are all clearly very smart and take this very seriously, you can't know in advance what is and is not going to be contentious or significant. Because it could, an officer contradicting another officer can be the beginning of a thread that unspools the entire prosecution. It changes the perspective of the court. It can lead to an acquittal, or frankly, can justify a conviction. You can't know that until you're in possession of all the facts. So that's my answer to your question.
Well, that would, thank you for that. Perhaps you could also speak to whether you see this separation of having a stream of offenses that would be eligible for a preliminary inquiry, namely those wherein the maximum sentence is life, and for all other offenses there would be no opportunity to have a preliminary inquiry, even though in a case of a robbery offense, for example, that might have a maximum of life, there would be a preliminary inquiry option. But for another offense, such as a drug trafficking offense, the sentence that the judge would likely apply might be the same, but in that case, there would be no preliminary inquiry. So how much sense does that make?
It doesn't make a lot of sense. It seems to me very arbitrary. And I understand that the drafters of this legislation were probably trying to figure out how to cut this off and how to make it, maybe in the most serious cases, you do need a prelim. But that's not how prelims work, and that's not the function that they serve in real-life criminal trials. We, based on the issues, elect to have a prelim or not. Very often, I'll take an indictable matter to a straight OCJ trial, OCJ being the Ontario Court of Justice, provincial-level trial, because there is no point to having a prelim. I just want to go, it's a simple matter, I want to get this done as quickly as possible, and so does my client. And there may be something where the maximum sentence is currently somewhere in the range of 5 years or something like that. But the issues are such that you absolutely need a prelim. And I talk about this a little bit in my brief, the issue of 278, because I think one of the unintended consequences of this legislation is that you are going to have, in matters that are serious, that are subject to the regime, the Mills 278 regime, which I talk about in my brief, but for anyone who hasn't had a chance to read my brief, is third-party records where there are, to put it as broadly as possible, sexual allegations involved. There's a special set of protections, and one of the most important sets of or protections in the regime is the complainant or witness is not compellable on a third-party records application. What that means is, if I want to establish the existence of records in order to be able to bring them to court and apply for access to them before the trial starts, I use the prelim to do that, because the complainant is there at prelim. She's not compelled at the application. The prelim is where we build the record to bring the application. Well, if that process is not available, suddenly we're in superior court, if it's a serious matter, and we're superior court in front of a jury, potentially. The complainant's on the stand, and I'm asking him or her about records which I need in order for the court to do its job finding facts. And I'm building the record to bring a third-party records application. I then bring the application mid-trial. The complainant is entitled to retain counsel. The record holders, be they doctors or institutions, are entitled to retain counsel. We have a long adjournment to deal with this, maybe a mistrial, because we've got a jury sitting there wondering what the hell is going on. And that's not conducive to a swift and effective justice system. So, I mean, I'm going on longer probably than you wanted me to in answering this question, but it really shows how this particular legislation in the context of a criminal code which has provisions like that, is going to create train wrecks. I hope that answers your question.
Yes, thank you. That's helpful.
Thank you, Chair, and thank you to the witnesses for your testimony. Mr. Hetcher, if I may, so I, during my articles, seems like a lifetime ago, was prosecutor for the provincial court, also known as traffic tickets court.
Provincial offenses.
Yes. In that, we received, dockets of over 50 at a time, where you would have so many police officers just kind of waiting around to give their testimony. Now, my understanding, and then the way that I understand routine police evidence, is that there's still a discretion of the judge to decide whether an officer should be brought in for cross-examination or examination themselves. In your experience, and I'll ask both of you to provide your feedback, in your experience, how many times or what is the percentage of a police officer's evidence being provided is actually needs to be questioned? And if it's not, 9 times out of 10, and it is in the judge's discretion to allow for cross-examination as is required for the administration of justice, do you not think that this would impact in a positive way delays that our court system faces, and also the challenges that our police forces in terms of their just having police on the streets?
I can tell you that I don't spend a lot of time in traffic ticket court, so I'm dealing with matters that where police evidence is more often more involved than I stopped this car, I gave him a ticket, I moved on. That said, I'm sure my friend will agree with this proposition. Crown and Defense Counsel routinely before a trial try to narrow the issues. And if there is an officer whose evidence is not strictly required, and we can put it in an agreed statement of fact before the court, or it's just really not that important for either of us, even though they may have relevant evidence to give on some issue, which neither of us think is going to make any difference at trial, then we can dispense with the evidence already. That already happens, and it happens a lot. I did a murder trial, which took a long time, but we had 14 separate, distinct agreed statements of fact on different sets of issues that we put before the jury. It's a system that works, and that the litigators themselves, who know what is and is not important, can control to ensure that the court has everything it needs to make a safe and sound finding of fact. And I recognize that sometimes officers sit around for a while. That is perhaps a little bit less efficient than we'd all like to see. But there was an article that was written by Michael Bryant, former Attorney General of Ontario, in which he said that efficient justice is kind of like efficient music or efficient circumcision. Not a really good idea. There's a certain point at which efficiency can trump justice, and you cannot take efficiency to the point where it gets in the way of justice being done. And so there has to be a point somewhere, and I think forcing the defense to apply for an officer to come and then give evidence so that they can be cross-examined, and in some cases having to reveal why it is they want to cross-examine that officer when they are trying to establish something like a charter breach or something else, we do in our notices of charter applications set out the basic things that we're alleging. But it is sometimes, there's a case, or a set of cases out of Alberta called Evanson, which talks about the danger of giving too much information to a witness, even a well-intentioned witness, in advance, because it can change in retrospect when they think about things, their own memory of how something went down at the time. Cross-examination is a difficult process, and one that we have to preserve and protect.
So my understanding, though, the way that I read the provision is that it's a decision between counsel and the judge, not the police officer,
No.
him or herself.
Yeah, but if counsel has to apply, then they're providing to the court and the prosecution and to the public, ultimately, unless the application is sealed, all the information about what they want and why they think the officer should be there. There's nothing stopping the officer from getting that information.
Mr. Woodburn, do you have some input?
Not as much as that. But my friend's correct in some aspects. Look, we have agreed statement of facts all the time. It's not an issue. As far as the section goes, if we need to call a police officer, we will, and sometimes they have to wait around, and that's what happens. A lot of the, in quotation marks, routine police evidence, two officers can speak to the same thing. We call one of them. It's easier and faster just to call the officer than it is to draft, get permission, do everything else. Overall, we're going to end up just calling the officer.
So, again, I just want to clarify so that I understand this correctly. Basically, what this routine evidence provision does is that it takes the discretion away from the council and puts it in the hands of the judge to decide whether or not a police officer will be examined and cross-examined, and what the agreed quote-unquote statement of facts is.
It is in some aspect, because ultimately when we make when the Crown applies and puts forward the affidavit and the defense says they want to cross-examine, then the judge ultimately makes the decision. But in reality and on the ground, it's not going to happen that way. We're either going to make our agreement between ourselves that it can go in, or I'm just going to call the police officer. It's pretty straightforward because that procedure will bog things down. That's not what we want. We want efficiency. So I mean, ultimately, we'll end up just calling the police officer. So
if we have to litigate this, it's going to take a long time, and it's going to slow things down rather than speed them up.
Do I have time for one more question?
Sure, one brief question.
Thank you, and I do want to address Mr. Sewell. You spoke a little bit about racism and inclusion within the justice system. That's not something, in my opinion, that we can legislate. How far do you think we need to go in terms of providing training to police officers, to judges, to court personnel, in order to really address issues like carding, for example, as you had noted?
Well, the way that carding has been dealt with in Ontario is that, in fact, the government has passed a regulation basically very, very much restricting what can happen. I think trying to deal with racism in the police force is a very, very complicated matter. I'm not sure it can be legislated. I think it has a lot to do with how officers are recruited, how they are trained, and how, in fact, police forces are managed. All those things have to change. And I mean, I think that we could have a very interesting discussion as to the changes that should happen, such as the fact that we should stop hiring officers at the very bottom and slowly progress them up through the system. We should have job descriptions for what they're going to do, what positions they're going to hold, just like every other organization in Canada. And that would, I think, start to deal very considerably with racism. Similarly, hiring people from outside to be senior managers in police forces will seriously cut down on racism. I think as an example, if police forces hired, as an example, some senior bank managers in their senior positions, there would be a major change in what was permitted in police forces and what is not. But having an interior culture that never changes because everybody comes from the bottom and works their way up, that reinforces things like racism, and that should change. I agree that cannot be accomplished by legislation, but it certainly can be accomplished by practice and by government leaders like yourself arguing that's what should be happening, and police forces should be changing in that way.
Thank you so much.
Mr. Rankin.
Thanks to all the witnesses. I'd like to, if I may, start with Mr. Hector. Thank you for reminding us about the reality of wrongful convictions. And I know you've, in your very helpful brief, you've made 4 recommendations, one of which relates to the disclosure issue and particularly the wrongful conviction of James Driscoll. I want to go there, but I want to start with what I think is the first time we've had a recommendation on this issue. You've made 4, as I said, the first of which is that you recommend we enact a criminal offense with respect to non-disclosure, that there should be in the criminal code, you argue, a penalty for non-disclosure. I'd like you to speak a little bit longer about that suggestion. It is your opinion that the Crown and the police are ignoring their obligations to such an extent that such a provision would be necessary?
Well, we have a treason provision in the criminal code, not because treason happens all the time, but because when it does, it's incredibly serious. And non-disclosure has been identified as in many cases, the primary reason for wrongful convictions in pretty much every wrongful conviction study in this country and elsewhere. Just this summer, the UK, in fact, a committee very similar to this, did a study. The House of Commons Justice Committee in the UK did a major inquiry into a bunch of disclosure problems that had led to hundreds of cases being stayed or withdrawn. Alison Saunders, the Director of Public Prosecutions, told the committee that people had been imprisoned because of failures in disclosure. This has tremendous tragic impacts on people's lives, and it continues to happen. I cite a case in my brief that I just finished up. We got a verdict in January, a triple homicide, where Justice Dawson of the Superior Court in Brampton found non-disclosure, cover-ups, perjury. This is unusual, don't get me wrong, but when it does happen, the officers involved shouldn't be promoted. And guess what? They were. The Peel Regional Police, and I'm not going to name the officers, they're all named in the decision, and the decision is cited in my brief. The major officers have all been promoted within that service. That can't continue.
Okay, thank you. In the interest of time, I want to get to the other recommendations. You specifically referenced Justice Lesage, who you say talked about the importance of preliminary inquiries in his report on the wrongful conviction of James Driscoll. Yep. In part, you say, because there were serious problems with disclosure in that case. Question. Yeah. And I want to ask as well, Mr. Sewell, to comment on whether such a provision, a penal provision for non-disclosure of important information would be helpful. But my question to you is: we had Mr. Daniel Brown yesterday also quote Justice Lesage in the Driscoll case, and maybe you can tell us more about why you think eliminating preliminary inquiries will cause more wrongful convictions. Some contend that the same evidence will come out at the trial just at a later date. Could you elaborate?
Is that for me or Mr. Sewell?
For you.
Okay.
First, and then Mr. Sewell.
There's a real misconception that has to be dispelled here. Prelims and trials are two very different animals. We do different things in them. And prelims and disclosure have two very different functions. Prelims are a discovery process for the defense as much as they are a charge screening process for the court and the Crown. And so, take, for example, sex assault cases. We know that police, and I talk about this in my brief as well, have been trained and are encouraged to assure complainants that they are safe in making their reporting, and this is a very good thing, that they are going to be believed. And in fact, I give you the website of the Toronto Police Service sex assault information page. They say, even if we don't lay a charge, that doesn't mean you weren't believed. Even if the accused is acquitted, that doesn't mean you weren't believed. And of course, that's true. They ask questions to support their investigation and help to validate the feelings of the complainant. We ask questions at a prelim for a very different reason, because we're going to be doing further investigation to prepare for trial. That's one of the things I was talking about with third-party records. There are other ways that we investigate to ensure that we're prepared for trial so that the trier of fact, be it a judge or a jury, is in a position to get the best possible information to arrive at a verdict. The police and defense counsel have very different roles, which is why disclosure and the discovery function of the prelim are two very different things. Depriving us of that discovery function can make it impossible to get all the appropriate and relevant facts before the court and can lead to wrongful convictions.
Okay,
That's what Justice Lesage found in the Driscoll case.
And I'd like to ask you, Mr. Sewell, if I could, to comment. Would you, in light of what you've put in your very helpful submission, would you think that there ought to be a penalty on police and the Crown who fail to meet their elementary disclosure obligations? Would that help?
The function of the police should not be to get a conviction, but to, in fact, ensure that justice is done. And too often, I think, police think, no, our job is to get a conviction. And to that extent, I think that sometimes some officers actually don't reveal all of the evidence that's there. So I think a penalty for non-disclosure is a good idea.
30 seconds.
Oh, okay. I just want then to, for the complete, you've recommended, Mr. Hector, the recommendation 3 that we should provide evidence in support of abolishing preliminary inquiries. Is that simply making the point that evidence-based decision-making requires us to demonstrate? And for the record, your fourth recommendation, joined in by so many other people, is that we should delete the provisions related to routine police evidence.
Yeah, I don't
Not,
think
not
this-
amend them, but simply delete them. Have I got that right?
Absolutely.
Thank you.
And Mr. Fraser was going to do this round, but he's not here, so he asked me to do that for him. Folks, I'm going to ask you questions. I'm going to try to get in a lot of questions, and if you could just give me succinct answers, I'd really appreciate it. With respect, by the way, Mr. Sewell, with respect to routine police evidence, I've already been convinced that there's an inherent problem with the routine police evidence, so I'm probably not going to be asking you questions because I'm already satisfied on that issue. With respect to your testimony, Mr. Hector, I was very struck by the comment that you made with respect to the example in the Superior Court where you'd be seeking third-party evidence and you would need to question the alleged victim in that situation and perhaps delay the trial, and that person would then have to come back potentially multiple times as you continue to investigate. You had mentioned, Mr. Woodburn, in your testimony that one of the advantages or one of the potential advantages was to prevent the victim from having to testify both at the preliminary inquiry and at the actual trial. Can you see the concern that was raised by Mr. Hector and by other witnesses that this could actually compound the problem by causing excessive delays at trial and also requiring the victim to have to come back multiple times as you were essentially conducting discovery by your cross-examination of the complainant?
Each one of these go case by case, and what my friend is talking about is a rarity in my experience. It's not something that happens a lot. Sexual assaults trials, for the most part, are a one-witness trial with maybe some collateral witnesses, and then it moves forward. The third-party records, in my experience, when there's been an issue and there hasn't been a preliminary inquiry, it's simply we put it before, it becomes part of the pre-trial process whereby we ferret through what we need at that point. And if the complainant needs to testify, and almost never does with regards to third-party records, then we can put her on the stand or him on the stand. But I don't see routinely that being an issue.
Perfect. On the preliminary inquiry side, back again to Mr. Hector, I don't think the disclosure penalties could actually be added to this law. I mean, I don't think it would be receivable as an amendment because it wasn't contemplated in the original draft. But were we to, for example, allow for a broader set of preliminary inquiries, for example, any penalty where any offense where the penalty was over 5 years, for example, in prison, and allow for preliminary inquiries to occur where the parties both agreed. Or, for example, that you can also file an application where in the interest of justice you should have a preliminary inquiry. Would you say that would generally resolve your concerns with respect to limiting the amount of preliminary inquiries that were permitted under the code?
I'm going to be as succinct as I can, and I'll answer those because that was a sort of tripartite question. One, I don't think using sentence length as a proxy for the need for a prelim is appropriate. It just doesn't. They're two different questions, and you're saying, here's an apple. What does that tell us about oranges? It will not help. So I don't think that's helpful. Can't remember what the second one was.
The second one was when the parties agree.
When the parties agree. Well, when the parties agree, then yes, I think that should be the case.
Yeah.
And a leave provision might be better than nothing, but in my respectful submission, I just don't think limiting prelims, because we already have the opportunity, if you've got a prelim, to agree, for example, to concede committal. One of your colleagues in the House, whose name escapes me at the moment, suggested that discoveries are a way around this. Well, discoveries in Ontario, at least, the practice we have is, if there's going to be a discovery, we schedule a prelim, but I concede committal, so we don't need a judge in the room. There's no jurisdiction in the code right now to have a discovery without the prelim being the kind of procedural framework for it. So there's all sorts of things we can do to encourage discoveries. I don't think we should be tinkering with limiting prelims when there's other things we can do.
Thank you. Mr. Woodburn, on preemptory challenges, I got your point. What would your feelings be if we, for example, introduced the Batson test into Canada that they have in the United States, where you can't do a preemptory challenge for a discriminatory cause, and if you were to do so, you could be called on it and have to justify your challenge?
it's a tough question because when in the U.S. The jury system is taken as a whole. So, I mean, you kind of move through it. Right now, we're inserting things in piecemeal, and in our view, it won't work. The issue that we're having is that we're getting closer to that with this whole notion that challenge for cause hearings start to become those, in the sense that the questions are put to the juror, and then we argue about the juror, and then the judge makes the decision. So it's very close to what's happening in the States right now.
But in this case, if you were to use that as a component, you'd retain your preemptory challenges, and then it would be up to the other side to say, hey, I think you're using them for a discriminatory reason, and that would possibly in itself limit the number of times that any of you would ever even contemplate doing that, because they could be called out on it. I mean, would that be a preferable solution to you than stripping them from your repertoire of things that you can do?
I can't really comment on that, because it just doesn't. It still doesn't make sense in our system from my point of view. It just doesn't.
Okay, fair enough. That exhausts my 6 minutes. Anybody else have a short question before we go to our next panel? If not, I want to thank our witnesses. Mr. Sewell, thank you for coming to us all the way from BC. I'm sure Mr. Rankin was thrilled that you were vacationing in his province. And I really appreciate both of your testimony as well. It was very helpful to the committee. I'd like to ask the next panel to come forward, and we're going to go into brief recess. And colleagues, we're combining the next two panels so that we can do one panel, and that will be our last panel of the day. is a great pleasure to convene with our last panel of the day. We are, so colleagues, on the agenda, the 6:30 to 7:30 and the 7:30 to 8 panel are combined. We have testifying before us today as individuals, Ms. Maureen Biznicki, welcome. Mr. Christian Luprecht, who is a professor, Department of Political Science at the Royal Military College, welcome. We have from the Evangelical Fellowship of Canada, Ms. Julia Beasley, the Director of Public Policy, welcome. De l'Association des familles de personnes assassinées.
From the Association of Murdered and Disappeared Persons, we have Nancy Roy, who is
le directeur général, et Monsieur Bruno Serré, membre de
and Mr. Bruno Serré, who is a member of the executive. Good evening.
Organization for Victim Assistance. We have Ms. Karen Wiebe by video conference from Winnipeg. Welcome, Ms. Wiebe.
Thank you. Nice to be there.
And so, folks, what we normally do is we put the person on video conference first in case, God forbid, we lose the video conference. So, Ms. Wiebe, if it's okay with you, you have 8 minutes, and I'm going to ask you to go first, okay?
Sure, certainly.
Thank you.
Well, thank you for this opportunity to address the Standing Committee on issues that are of particular importance to victims of homicide. MOVA is a support organization consisting of families of homicide victims whose sole goal is to support other families of homicide victims. I would like to speak to you today about 4 pressing issues that are of particular importance to people like me, because you see, I too am the mother of a murdered child. My son TJ had his life taken on January the 3rd, 2003. The issues that I bring forward to you today are not only issues that I know about from my own experience, but also ones that I've gathered from other families. The first issue is representation of victims throughout the review process. The first issue that I'd like to speak to is the poor representation of victims throughout not only the justice system as it has always been, but even through the justice review process. The view of those who are requesting change for the accused has been disproportionately requested compared to the view of victims. And yet for every offender, there are between 1 and 10 immediately affected victims whose needs are addressed in only the most summary fashion. Victims are re-victimized over and over again by a process that has no place for them. And yet these victims and co-victims must try to regain their lives with next to no supports, which in turn results in drains on the healthcare and policing systems, to name only a couple. We constantly hear about the rights of the accused and the rights of the offender, and the judicial system makes every effort to adhere to those rights. But we seldom discuss the rights of the victim and co-victims and the supports to them that are almost non-existent. As we are looking at reforms of our criminal justice system, we need to put greater emphasis on the rights and needs of victims and co-victims. People, citizens of Canada, whom have had their lives stolen by the actions of another individual or individuals through no fault and no intention of their own. In one case in Manitoba, where a young man was murdered on a Greyhound bus, 15 of the people who were riding on the bus that day and who assisted to the bus that day were interviewed. Of the 15, all were still suffering after effects 10 years later. One person committed suicide. A new mother had her child taken by CFS because of her inability to properly care for her child. Others were also suffering from PTSD. Still others were no longer able to hold on to a job and were needing assistance from welfare. But where are the supports for those people? And in turn for their families? A few dollars provincially for counseling? Where do we even talk about them and their needs? Who even cares what happens to them? Are they a drain on public systems? Absolutely. Even economically, it makes sense to support those people following the incident, to recognize them and to provide assistance for their return to a somewhat normal life. The second issue that I'd like to speak with you about is the reclassification of offenses. Currently, charges of murder in the first and second degree are often plea bargained down to manslaughter. I realize that this is done for a variety of reasons. There needs to be a separation between cases where a person is charged with an accidental death and a person is plea bargained to manslaughter. They are not the same. However, we have had several cases in Manitoba where, because time spent in custody pre-sentence is realized at time and a half, the offender serves a minimal amount of time following sentencing, sometimes finding that their sentence has been completely served by the time of sentencing. In cases where there has been a deliberate act in the taking of a life, pre-sentence time should not be allowed to be represented as time and a half. It should be represented in the same way as time served for murder or second-degree murder. The issue could be solved if manslaughter could be divided into two categories, one where the plea bargain could fit and one where accidental death would fit. A common factor for all victims is that the person who deliberately took the life of their loved one be held accountable. We don't want the wrong person prosecuted, but we want the right person to be held accountable. When an initial charge of first or second degree murder is made, the charge is based on a deliberate act. That needs to be recognized in sentencing. The third issue that I'd like to speak with you about is the issue of the NCR, or not criminally responsible. Families of homicide victims understand the implications of the NCR findings more than anyone other than the offender. The issue of mental illness is a huge and timely discussion that is happening throughout many departments and institutions in Canada. Families of victims whose lives have been taken by someone who subsequently has been found NCR are in disbelief that when someone is found NCR in a murder case, there is no requirement to follow them, to make sure that they are complying to the directions of doctors who will make sure that they take the medications to keep them on track. It's in these cases, it is as if the healthcare system and the criminal justice system are failing not only the victim, but the offender, him or herself. If that person offends again because they have stopped taking their meds for whatever reason, they will end up in the criminal justice system again, and they will leave more victims in their wake. This could all be avoided if there was a requirement that those who have committed a murder and who are found NCR would still be followed to make sure they remain on their medications. The last issue that I'd like to speak with you about is the lengthy trial delays. And this is an issue that I realize and I understand that there's been a lot of work done across Canada on this. Justice delayed is justice denied. That is true for the accused, but it is also true for victims. In Manitoba, we have a case that took 8 years from the date of the offense to the date of appeal dismissal. There were 2 accused, and they were found guilty of first-degree murder. They had both achieved bail pre-trial. They have now been incarcerated for 4 years, and one is already applying for escorted absences. Certainly, this family was victimized by the killers of their son, but they were re-victimized by the judicial system over the period of 8 years that it took for the court processes to be resolved. And the re-victimization continues through a process that recognizes the rights of the offender, but only limited rights for the victim's family. Victims throughout Manitoba, and I'm sure throughout Canada, are thankful for the reforms that are speeding up the trial process. The stories of victims of homicide are months worth of telling, and the issues of re-victimization are many, many more than I am given time here to present to you. However, I appreciate the willingness of this committee to hear the issues that I am bringing forward to you today for your consideration. Thank you.
Thank you very much. Thank you very much, Ms. Wieben, and of course, I think all of our sympathies for what you and your family have gone through. Because I think that Madame Roy and Monsieur Serré are speaking about the same issue, maybe we'll put them next as the next speakers, okay? Madame Roy, Monsieur Serré, c'est à vous maintenant.
You now have the floor. Thank you. The Association of Families of Murdered and Missing Persons is a nonprofit organization which represents families of persons who were assassinated. And it proposes a number of resources helping them to rebuild their lives. The core mandate then is to provide assistance to families that were affected this. Since 2005, we have provided assistance to hundreds of persons affected by such a homicide throughout Quebec in order to provide them with moral, psychological, and legal support and help them to deal with their grief and resume their life. We wish to thank the Standing Committee on Legal and Constitutional Affairs for the opportunity to submit our brief on the Bill C-65. It is particularly important for us to present our opinions so that legislators give some thought to the fate of victims and their family members, and to give a greater emphasis to the security of victims, which unfortunately has been greatly weakened by the proposed changes in this bill. Victims are often overlooked in legislative changes. We do not wish to intervene on all the points discussed in the Act, but we'd like to draw your attention to two major points. The first of it, we are pleased to note that the notion of intimate partner has been added to Section 2 of the Code. Subclauses 227 and 3 and 6, amending Section 555, introduce a major change by introducing a reversal of the burden of proof in conditional release applications when an offender is charged with that type of offense. However, this provision applies only to a repeat offender previously convicted of an offense against an intimate partner. We are very concerned about this notion of recidivism because a number of our families have seen the family members killed within the context of family violence or marital violence. We must realize that this is a delicate situation and is often overlooked. This should incite legislators to exercise greater caution towards potential victims. This excessive caution with respect to recidivism does little to protect victims. These victims are entitled to protection under the Canadian Charter of Victims' Rights. Therefore, we should make use of this. We have to withdraw the notion of recidivism or repeat offense if we wish to obtain the laudable objective of protecting victims. The second important point that we wish to mention is the modernization of practices and procedures with respect to conditional or with respect to bail. Bill C-75 brings a number of amendments aimed at modernizing practices and procedures with respect to conditional liberty or release. The bill reorganizes a number of provisions and procedures in order to encourage conditional release. Can you identify a single accused person who will admit to the judge that he does not intend to respect whatever conditions may be imposed? The desire to reduce delays and to administer justice in the most efficient manner possible does in fact reduce the attention given to victims. The right under the Charter to presumed aggressors would appear to be the predominant consideration and considered more important than the protection and safeguard of lives and rights in the Canadian Charter of Victims. How will greater protection be given to vulnerable victims who are fragilized by this notion of quick conditional release with the fewest possible conditions? I'm very worried by this because, unfortunately, these victims did not have a second chance. And to continue in this vein, my name is Bruno Serre. I am the president of Brigitte Serre, who was murdered on 25th of January 2006, when she was 17 years old. I've been a member of our association for the past 10 years, and I'm a member of the council, and I'm here as a volunteer to make you aware of the legislative absence or omission with respect to victims. Even though I've appeared many times for the adoption of the Canadian Charter of Victims, I do not see much concern for this in this particular legislation. How do you intend to protect all these victims who are afraid, that have denounced their aggressor, or aggressor who is quickly released in conditions that are not severe, unless it is a repeat offender? Brigitte Serre, Daphné Baudreau, Cheryl Beautremblay, Gabrielle Elie Dufresne, Francine Brissonnette, and all these others. Do you think that they ever had a second chance? No, they were all murdered. And by people who were not repeat offenders. I urge you then to withdraw this notion of repeat offense and to give greater emphasis to the notion of protection of victims. The reversal of the onus of proofs for conditional release should be systematic when there has been violence towards a victim. How can we protect victims otherwise? We might perhaps put them in ivory tower. Ask these terrorized victims what they think. I can tell you that in the past 10 years that I have seen many families in such circumstances that have gone through these terrible situations, and there is very little help provided to them. They are very often fearful. And when crimes of passion are committed, such as these ones where there is violence, we often find ourselves with families whose members have been killed. We have to go against this worrisome trend.
So sorry, now we're going to go back to the order on the agenda, and I apologize for the diversion. Ms. Beznicki, the floor is yours.
Thank you. Good evening, and thank you for your invitation today to discuss Bill C-75. My name is Maureen Baznicki. I am the co-founder of the Canadian Coalition Against Terror. I'm also the founder of the Canadian National Day of Service Foundation. Over the years, I've had the opportunity to address both House and Senate committees, re many topics concerning terrorism, counterterrorism initiatives, and advocating for victims of violent crime, which includes Canadians victimized by terrorists. I was one of the original recipients of the Queen's Diamond Jubilee Award for my enduring dialogue on terrorism, and it is through this lens that I'm giving a brief today, and I thank you for the opportunity to do so. On September the 11th, 2001, my life changed forever when my husband Ken was murdered in the attacks on 9/11. He was a proud Canadian who lived and worked from his home in Toronto. Ken was on his first trip to New York to network for his job. In the aftermath of the horrific attacks, I decided that I wanted to do something to ensure that no family has to go through what mine did, and I shared this with other victims. I'm a very proud Canadian, as was my late husband Ken. Even though Ken was murdered outside our border, it is important for me to have my country send a proper message in the global community that my Canada will not tolerate anyone, either a Canadian citizen or a citizen from another country, deliberately trying to harm or murder innocent civilians. That is why I co-founded CCAT, along with my friend and colleague Danny Eisen. For those of you who are unaware, the Canadian Coalition Against Terror is a nonpartisan policy research and advocacy body committed to seeking innovative legal and public policy strategies in the fight against terrorism. In that context, I would like to speak to you about some of what is contained in this legislation that concerns me greatly. The government has used the anodyne term hybridization to refer to more than 100 changes that they are making to sentencing provisions in the criminal code. However, it is clear that what is happening here is simply a reduction in sentences. I would particularly like to speak to clauses 16, 17, and 20 to 23. These are all provisions relating to terrorism. Currently, providing property or services for terrorist purposes could be punished by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. Currently, using or possessing property for terrorist purposes could be punishable by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. Currently, the participation in the activity of a terrorist group could be punishable by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. Currently, participation in terrorist activity could be punishable by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. Currently, leaving Canada to participate in terrorist activity could be punishable by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. Currently, advocating or promoting terrorism could be punishable up to 5 years in prison. Under this bill, the sentence could be as little as a fine. And lastly, harboring a terrorist is currently punishable by up to 10 years in prison. Under this bill, the sentence could be as little as a fine. The rationale provided by the government has been that there is a need to speed up the court system. On that point, I don't disagree. There are unconscionable delays in prosecuting criminals, and those delays are often led to criminals walking free on a technicality. But one has to wonder, is treating a terrorist in the same manner as someone who got a parking ticket the best way to fix a broken system? I would say absolutely not. It sends the wrong message to victims and to Canadian society as a whole. It sends the wrong message to other countries and would-be terrorists, either homegrown or from outside our borders. Terrorists, members of terrorist groups, and those who profit off of them should face the full force of the law. I have to wonder, since this government is often very fond of consultation, what groups were asking for this? I can't imagine that any of the members of Parliament on this committee knocked on a single door where someone told you that they were concerned that the punishment for terrorists was simply too harsh. I would recommend that this committee repeal all the provisions in this bill that lessen the penalties for terrorists. Unclogging the courts is certainly a noble objective, but there are many better ways to do that than have been attempted here. Victims have an important interest in the criminal justice system that is not delayed. Remedies emphasize both the rights of the accused and the rights of the victims must be found. I would like to close by stating Prime Minister Justin Trudeau's words when he was challenged by Canadians across the country with regards to the $10.5 million payout to satisfy the settlement regarding the violation of Omar Khadr's rights. He said, "The measure of a just society is not whether we stand up for people's rights when it is easy or popular to do so. It's whether we recognize rights when it is difficult. When it's unpopular, we are a society that stands up for people's rights, and when governments fail to respect people's rights, we all end up paying, and that is a lesson that hopefully future governments will draw from this settlement." I'd like to remind you it's the safety and security of citizens that is the primary responsibility of our Prime Minister. Ensuring that there are laws and penalties in place that send a strong message of condemnation and act as a deterrence are of vital importance to Canada. I am a Canadian who has been victimized by terrorism. I join many other victims of violent crime that, in our opinion, changing sentencing to minimum time in the case of heinous crimes committed by either terrorists, repeat offenders, drunk drivers, etc., lessens the rights of victims. Justice and accountability are not obtainable for all victims. However, when our security forces do get the perpetrator, I hope that our judicial system delivers the proper sentence that is fair to both the offender and the victim. I want my rights as a Canadian who has been victimized. Please do not decimate our criminal laws that will send the wrong message. Thank you, and I'll be pleased to take questions later.
Thank you, and again, the same as I mentioned to Ms. Wiebe, as I'm so sorry for what you went through. Professor Luprecht, you're next.
Bonsoir, mesdames et messieurs. Merci de votre
Good evening, ladies and gentlemen. Thank you for your invitation. It is a privilege for me to be able to speak to the committee.
And I come at this strictly as a political scientist, and I've also been asked to comment specifically on the issue of hybridization, so I shall limit my remarks to that particular remit. Il me ferait plaisir d'accueillir vos questions dans les deux langues officielles.
And I will be happy to answer your questions in either English or French.
With regards to hybridization here, is to provide an incentive for people to plead out, right? So if under an indictment you face a long sentence, you have not much of an incentive to plead. If under summary conviction you face a much shorter sentence, now you have a strong incentive to plead out. That incentive is reinforced by programs such as Justice on Track that provide a financial reward for Crowns to plead out on cases. And so the Crowns will be happy because this will result in more money in their pocket. But I have some concerns here. The first is that ultimately, as I point out in my submission, the vast bulk of cases go through provincial court. A tiny amount of cases go through Superior Court. And so this bill risks unclogging the Superior Court system at the cost of the provincial court system. And of course, since it also raises many of the potential maximums to 2 years less a day, it also risks reinforcing the number of people who find themselves in provincial systems where, by and large, they don't have access to the sort of programming they have in federal court. And so I'm not sure that having even fewer cases go through Superior Court than already do is really going to be particularly effective in terms of the correctional system that we have in place. Second, that we already have people who deliberately drag out the court process because they take advantage of dead time. So dead time, which used to be credited at 2-for-1, is now at the discretion of the judge, and so can now be credited at, and is often credited 1.5-for-1. And so now your incentive is to drag out the process as long as possible, because the longer you can drag it out, the less chances you have of ever doing any jail time under this new proposition if the offense is a summary conviction. So it will reduce the number of people who will effectively do any jail time under their sentence. Third, very few cases ever go to trial. Anyways, I provide some of the data here. It's well upwards of 90% of rates of cases that are cleared by other means than trial. And so to what extent is hybridization really going to achieve the objective of unclogging the court system? Many offenses are already hybridized, and what's particularly interesting here is, of course, the long list of acts and violations that are not currently criminal code violations, but other forms of violations. And so I particularly point to one particularly curious matter, which is that the Act lists the implications for every offense except for one, which is the exploitation and trafficking in persons, where the only reference is to another bill that is currently finding its way through Parliament. The reason why I pick out this particular example is because I'm not sure to what extent the Canadian public will tolerate hybridization for sentences that currently have 10-year maximums, because the reason is presumably to signal with these 10-year maximum sentences that these are serious offenses. And so if we now hybridize these offenses, the signal that we're sending is these offenses are no longer as serious as they were before. So we'll need to test that with public opinion. Fifth, that expanding the latitude for the Crowns has important procedural implications that I'm not sure have been carefully contemplated. So I list these implications, but it has implications with regards to warrants, with regards to statutory limitation and charges, with regards to fingerprints, with regards to the right to elect a trial by judge and jury, and when you can apply for a pardon. So we're talking about some fairly significant procedural changes here. Sixth, that Crown or police presumably lay charges for a reason. And the reason is that they believe there is a reasonable chance of obtaining a conviction. So shouldn't we let the justice system then take its course? Aren't we do a disservice to the law enforcement agencies and to the Crown who believe there was merit in laying a charge to begin with? And so what's the point of ultimately having a justice system when our sole objective now becomes to resolve as many cases as possible before they ever actually go to trial? Seventh, I have concerns about the implications for investigators, that by having fewer cases actually go to trial, it means that the few cases that actually come to trial are very serious cases that are going to be highly complex cases. But if we have fewer investigators having extensive experience being questioned by aggressive and very talented defense lawyers, I think there is a greater risk of ultimately these particularly complex and notorious cases subsequently failing as a result of inexperience of some of the law enforcement members that show up to provide testimony. And finally, my eighth point that has already been expanded upon in much more articulated manner than I ever could by the families of victims present here. I suspect that even though we have a Canadian Victims' Bill of Rights, this has already become rather a pro forma matter in terms of consultation, and it doesn't appear that the changes being proposed here will reassure their faith in the criminal justice system and are probably likely to be somewhat unpopular with victims. So in sum then, I would conclude that it appears that hybridization puts the benefits of the judicial process before the interests of victims, investigators, prosecutors, provinces, the public, and the integrity of the justice system and the rule of law. And so I'm afraid that I'm apprehensive about any legislative change that puts the merit of process before the merit of substance. Merci.
Thank you very much. Ms. Beasley.
Thank you, Mr. Chair, and members of the committee for the opportunity to participate in this study. The Evangelical Fellowship of Canada is the National Association of Evangelical Christians in Canada. Our affiliates include 45 denominations, more than 65 ministry organizations, and 35 post-secondary institutions. Established in 1964, the EFC provides a national forum for Canada's 4 million evangelicals and a constructive voice for biblical principles in life and society. Our approach to the issues we will address in Bill C-75 is based on biblical principles that teach respect for human life and dignity, care for the vulnerable, and freedom of religion, principles that are also reflected in Canadian law and policy. Bill C-75 proposes a significant number of changes to the criminal code, including the hybridization of a number of criminal code offenses. This would allow, as you know, some serious indictable offenses to be treated as relatively minor summary offenses at the discretion of the Crown. It's on this element of the bill that I've been asked to provide comment, and our concerns in this regard are limited to a few key areas. Criminal laws give expression to the norms that undergird a society. They both express and reinforce the basic commitments that bind a society together. It is often said that the law is a teacher. Amendments to the criminal code can signal or imply a shift in our society's core principles or their interpretation, which is sometimes appropriate. But this also means we must carefully consider the implications of any changes we make. The categorization of a criminal offense tends to indicate the seriousness of the conduct it addresses. Hybridization suggests that an offense can now be considered less of a violation of human dignity, less of a threat to society or social cohesion, and less harmful to the vulnerable among us. Respectfully, we submit that to hybridize some of the offenses proposed in this bill would send the wrong message. We understand that one of the objectives of hybridization is to reduce delays in the criminal justice system. But to paraphrase what Mr. Jeff Cowper told this committee last week, our goal should not be to reduce delays, but to deliver justice in a timely way that's responsive to the public interest, to the needs of the victim, and the community generally. When Bill C-75 proposes a greater maximum penalty for repeated intimate partner violence, and I hear the concerns of my co-panelists about recidivism, but this communicates that this is an offense the government considers to be very serious, that violence is unacceptable and is to be deterred with a severe penalty. This is a good message. Conversely, when the bill proposes to hybridize offenses related to human trafficking, sexual exploitation, or the assault of religious officiants, it sends the message, whether intended or not, that these offenses are of lesser concern. Bill C-75 proposes to hybridize Section 176(1) of the Criminal Code, which deals with obstructing or violence to an officiating clergy. Obstructing or assaulting a religious official who is about to perform religious duties strikes directly at the heart of religious belief and practice. Religious officials are not merely acting as individuals when they are carrying out their religious duties. They are representatives of the broader community of faith. Last year, more than 65 interfaith leaders wrote to the Minister of Justice expressing our deep concern with the repeal of the Section 176 protections that were proposed in Bill C-51. We wrote, "The deliberate assault of a religious official outside a house of worship is a different kind of offense from other public disturbances, assaults, threats, or incitement to hatred. An offense against a people at worship reverberates through the community and touches every member. Offenses against religious officials and people at worship are unique in character, in significance, and in motivation. And in a climate of increasing incidents of hate, specifically at and against places of worship, we believe it's essential to maintain the focused protection that Section 176 offers religious leaders. We are grateful that this committee heard the concerns of religious Canadians and recommended that Section 176 not be repealed, but instead revised to be more inclusive of all religious officials. We ask the committee, in keeping with that same understanding and responsiveness to the concerns of religious Canadians, to recommend that this offense not be hybridized in Bill C-75. You heard compelling testimony last night of the realities of human trafficking and all forms of sexual exploitation, and the devastating impact of these crimes on their victims. These crimes constitute a grave violation of human rights, including the rights of women and children to live free from violence. And it's essential that the gravity of these offenses be consistently reflected in our laws and policies. We know and have known for years that in Canada, it is mainly Canadian women and girls who are trafficked, and they're being trafficked into the commercial sex trade. 95% of all cases in Canada in which trafficking charges have been laid in the last 12 years were domestic and primarily involved sexual exploitation. StatsCan's latest report says that 95% of trafficking victims are female, 72% are under the age of 25, and 1 in 4 victims are under the age of 18. We're pleased that this government is taking action on human trafficking and is consulting on the development of a new national action plan. We're also eagerly awaiting this committee's report out of its study on human trafficking. But we're disappointed that Bill C-75 proposes to hybridize certain offenses related to human trafficking and sexual exploitation. These other initiatives demonstrate that this government rightly considers these crimes to be worthy of significant legislative and policy focus. But the proposed hybridization of related offenses seems to send a conflicting message. In particular, we note the bill's hybridization of the following. First, Section 210, keeping a common body house. This provision allows law enforcement to address the ownership and operation of brothels, which are often loosely disguised as spas, holistic centers, or massage parlors, in which individuals are frequently held, exploited, or trafficked. The naming and continued inclusion in the criminal code of such a place is significant because the existence and operation of these places can legitimize the hold, power, and influence of a pimp, trafficker, or exploiter over the exploited. As I was preparing, I spoke with a friend and colleague who has firsthand experiential knowledge of how these facilities operate, and she explained that pimps and traffickers use places like holistic centers and massage parlors with the full knowledge of the owner, and that placing their girls in a licensed facility legitimizes the pimp or trafficker as part of a business. Individuals who use these places to exploit do so with intention, forethought, and planning. The exploitation that occurs in these facilities is rampant. We need access points to these places, and we need to be careful that we don't limit or restrict the ability of law enforcement to monitor, to search, and to prosecute where needed. Rather than repealing this section as some have called for, or hybridizing it as this bill does, we suggest the committee consider clarifying the definition of body house in the criminal code. The current definition is imprecise, and that imprecision actually cloaks the exploitation that concerns us. So we would support a definition that makes it clear that the offense targets situations of sexual exploitation where individuals are held, kept, or exploited in a place where someone else is in control of their movement, their activity, and quite often their finances. Next, Section 279.021, material benefit with trafficking, and Section 279.031, withholding or destroying documents. These offenses, as they relate to the trafficking of a person under the age of 18, remain indictable. Our laws rightfully extend particular protections to children who are uniquely vulnerable in a number of ways. However, this bill would hybridize these same offenses as they relate to adult victims. This is problematic because exploited adults are quite often just exploited children who just happen to turn 18. In fact, often the only thing about their circumstances that has changed is that they are now 18. And the severity of the abuse they have suffered or continue to suffer does not lessen when they turn 18. Victims who become adults in the eyes of the law may already feel a bit left behind because the system offers them fewer supports and services and treats the crimes committed against them as less serious. I would argue that even in cases where the exploitation begins or occurs when the victim is an adult, we do not want to send the message that this conduct is less serious. Human trafficking and the criminal offenses associated with it must be considered very serious and dealt with accordingly. As such, we recommend that these offenses not be hybridized. And finally, Section 286.2.1, material benefit from sexual services. This provision is clearly aimed, and I suspect applied almost exclusively to individuals who are benefiting, as the law says, from the sale of someone else's sexual services. It is clear that what the current laws aim to do is prevent the exploitation of one individual by another. This offense and others covered by the Protection of Communities and Exploited Persons Act should not be hybridized. This act established an incredibly important shift in how our country addresses prostitution. It refocused our laws on the buyers and those who profit from exploitation, while decriminalizing those who are selling or being sold. We believe these laws are a critical tool in the fight against trafficking and sexual exploitation because they seek to curb the demand for paid sexual services, which is what fuels sex trafficking and funnels women into prostitution. The Act has a mandatory 5-year review built in. We strongly recommend that the government keep the current prostitution laws in place as they are, and when that 5-year mark is reached, conduct a thorough review of the laws and their effectiveness in order to determine how they may be strengthened or improved with the clear objective of eliminating sexual exploitation. Thank you.
Thank you very much. Thank you to all the witnesses. We're now going to go to questions. Mr. McKenzie.
Thank you, Chair, and thank you to the panels here. I'm really impressed. I'm just an old policeman. I'm not a lawyer. I haven't spent my life defending clients, but I have spent my life defending everyone, both sides of that equation, and that's the only fair way a police officer can function. But having said that, Ms. Wiebe and Mr. Seri, both of you have indicated the real pain of going through the loss of a loved one at someone else's hands. And can you explain to us that, and I suspect you will, that sentencing includes, or the trial includes the sentencing and the incarceration and what happens when people are released early from prison?
Who would you like to speak first?
You can go first.
Okay. The needs of homicide victims, of course, are very specific, I guess, more so than many crimes, because there is no coming back from a murder. When a person is murdered, they're gone. There's no way to fix it. There's no way to change it. There's no way to pay it back. And that's why, we need to look at the term restorative justice, for example, because there's no restoring in a homicide. So victims of homicide, co-victims of homicide, families and so on, of people that have lost their lives through the deliberate act of somebody else, are often very angry. They are victimized initially by the crime, but they feel re-victimized by the system. And then when the system fails them by allowing somebody to achieve parole early or to have plea bargain down to a lesser sentence that then, carries a very small amount of time, they feel even more angry and their anger is often then directed at the justice system. So there are many ways that victims are re-victimized through the process, and many ways where the offender's rights are valued greater than the victim's rights. Just in one minor thing, in terms of parole hearings, for example, when you go to a parole hearing as a victim, it's a shocking experience to go to a parole hearing. I remember being in shock, not remembering a lot of what happened in that parole hearing, coming face to face with the killer of my son. And at the end of it all, he gets a transcript of what went on in that parole hearing. I don't, because I was there. And yet I don't remember it. So I mean, that's one small example of how people are re-victimized over and over again. And there are many, many more. Perhaps I'll let the other person speak.
Sure, thank you very much. Sir?
To continue on this particular point, yes, when you are a victim, you don't have many rights. When you go to the court and you go before a judge, this is the first experience, and we would like to, would be the last experience. This is the first time we face this situation. We don't have any knowledge, we have no right, and we take a look at what is happening with the accused or the person who's charged who has all the rights. I was warned, for example, that if I didn't stop looking at this person, I would be expelled from the court and I wouldn't be able to attend the trial. How we feel when we're in this type of situation. In Facebook, for example, there's a statue and the center is completely empty. That's how you feel when you're a victim in this situation. There's the pain. You can't explain, of course, the kind of pain that the victim goes through. When I meet other victims, I can understand what their situation is. And there's no single victim was the same as the other. No one did I meet who went through things in the same way exactly? And it's something that you have to go through over and over again. You can't explain, and people have different approaches. Unfortunately, people are not always well informed as victims. A great deal of importance is given to the accused, but not to the victim. All you have to do is give people more information, take care of the victims, and to inform them. For example, victims in cases of family violence, they are not protected, and if it is denounced, then of course they're going to undergo further threats.
Wonder about this government's priorities. This is a government that has taken more than a year to fill the Victims Ombudsman. We have government MPs who voted against legislation to strengthen the independence of the Victims Ombudsman. We have, as Ms. Bizneski pointed out, a government that enriched Omar Khadr with $10.5 million, and now this. Hybridizing offenses, the most serious of offenses imaginable, not the most serious imaginable, but among the most serious in the criminal code, including terrorism-related offenses, impaired driving-related offenses, material benefit in the context of trafficking, human trafficking, and for what? To download these cases onto provincial courts that are already overstretched and overburdened, that will now have an 18-month rather than 30-month Jordan timeline. How does that make sense? Whoever wishes to answer. Well, it's a question
Question
and
for
it's
the
also the
witnesses. So
first time
we're past 6.5 minutes. So if anybody wants to have a brief answer, we can. Is there anybody who wants to actually answer that?
Well, look, I think sorry, go ahead. Oh, please go ahead.
Is there anybody who is answering?
I think someone is
I can answer, but yes, I can answer that. Yeah, this is a very large hole and a very difficult topic to discuss because victims are in agony for as long as the rest of their lives. And when you have a trial that takes, as a case that I stated, 8 years, where actually these parents were also witnesses, so they couldn't even attend the trial until after they had given testimony. So they didn't even know all the details of the trial. In those situations where it is so elongated, it's ridiculous. And yet 15 or 18 months rather, or a much smaller length of time to try and deal with those cases. One wonders if that can cover everything. That wonders if justice can be served in that amount of time. It's who is doing the work? Does it mean that if there's no preliminary hearing, that the case is going to be handled as appropriately as possible? So it's very difficult to try and. Sorry, I'm getting an echo here. It's making it difficult to hear. It's very difficult to give a certain length of time that all trials should be done by. Unloading onto provincial courts is not the answer, but I think both the federal and the provincial justice systems need to work together to make sure that there isn't an 8-year trial process, but that there is a process that is appropriate to what is needed for those cases so that justice can be served for everybody involved.
Thank you. Mr. Boissonneau.
Merci, Monsieur le Président, et merci à tous les témoins.
Thank you, Mr. Chair, and thank you to all the witnesses who have spoken here. I'd like to direct my comments to Ms. Roy. Ms. Roy, I'd like to know whether you've looked at section 1.3, where we added the definition of intimate partner in section 2, and you are pleased with this addition? Yes, certainly. This is what we said today. We said that we were pleased to see that this was added, but unfortunately, it does have a restriction with respect to a repeat offense. And we in Quebec, I'm not sure what the practice is in the rest of Canada, but every week we in Quebec have seen an epidemic of young women being killed, not by repeat offenders. And this is why we are asking the question, can we have the courage today to represent victims, because we do have a charter. I have 3 other questions, and I have only 5.5 minutes, so I'd like to put my other question. The terminology being used in French, partenaire amoureux, is it similar to dating partner? And if not, what do you think? I'm not a specialist in translation. You don't need to be. We felt that this did express the problem, but we put our emphasis on this matter of a repeat offense, and this is why we wanted to be taken away, because it's not the type of situation that occurs that often. You talked about the fact that you were pleased with the reversal of onus of proof, but you do not like this situation with respect to recidivism. Can you explain why? The reversal of the onus of proof is something that reinforces the protection for victims, in our view. It is also almost in keeping with what our request, that is preventive arrest, in order to calm down the aggressor. And if we reverse the onus of proof, then this means that all the attention is being focused on the aggressor rather than the victim. And the aggressor must demonstrate that he is not dangerous, and this provides greater protection to victims. We consider this to be a major element because it's almost the equivalent of a preventive arrest. This is something that we would have liked, but it would never go through the test of constitutionality. Maybe I began too quickly. I wanted, first of all, of course, to thank you for your work. I did lose my sister when she was 27. She was younger than me. We don't know what the cause of her death was. 30 years later, we still don't know why Lisa died. And I wasn't able to, I wasn't in a similar situation to yours. And I'd like to recognize all the work that you have been doing on behalf of the community. We have a very delicate issue. That is this matter of preliminary inquiries, because we did hear during in our study of human trafficking that it is more frequent than not than when someone wants to get out of this situation, when there is a trial, it's not only twice or 3 or 4 times. There's a preliminary investigation. It is necessary to provide testimony, and every time this re-victimizes the person or the witnesses. I'd like to know whether you consider this to be similar to the type of experience of the victims that you've been working with. I can answer this question. Yes, this is extremely difficult for victims to live through more than one trial or investigation. If there is a second trial, for example, it means that you have to go through the same thing 2 years later. You find yourselves facing the same type of anxiety and go through the same thing. You'll go through the whole process all over again. And this, of course, is something that victims would like to avoid. The fewer trials, the better. In your opinion, then, removing preliminary inquiries would provide greater protection to victims? Yes, we think so. Because there's often a deterrent effect. When victims go through a legal process, very often they are deterred from continuing to provide testimony. We think that it is important to protect them as much as possible and to try to remove the situations where they are very vulnerable. Thank you.
Section 75, the repeal of the Body House laws, your clarification suggestion. In your opinion, that clarification would still permit the gay men who were arrested in the bathhouse raids from the 80s into the 2000s to be able to have those records expunged. If that could be clarified and we could then do what we need to do with that other piece of legislation, your recommendation wouldn't stop that from taking place. That was not your intention.
That was certainly not our intention. Like I said, our interest in that provision is that it enables us to look at places where individuals are held and exploited, quite often trafficked. The definition is really quite vague. And I think, we can accomplish a lot by bringing some precision to that definition and making it very, very clear what it is we're addressing, what we're after.
Thank you very much. I have 1 minute for Mr. Varani. 30 seconds.
Time. We'll go to Mr. Varani, hopefully for the next round of questions. Perhaps Mr. McKinnon will let him have the first part of the next round. We'll see. Mr. Rankin.
Thanks, Jared. Thank you to all the witnesses. I want to start, if I may, with Professor Luprecht. Your unintended consequences, you were good enough to list them one by one, 8 in number, I think. I'd like to start with the one that caught my attention, and that is the issue of hybridization. In fact, taking a backlog in the superior courts and visiting that on the provincial courts. Sounds a lot like downloading by the federal government to me. I thought your statistics about how we have 99.6% of criminal cases already going through the provincial courts was very, very sobering. And the implications of hybridization, I think I understand you to say, would be that even fewer cases go through the Superior Court, all of which would lead to enormous additional expenses for the provinces. So my question is, in the research that you've done, is there any empirical evidence on how much the additional cost would be?
So I've done an entire book on the Canadian Constitution and issues arising from that, and I'm also a scholar of federalism and an associate of the best-known institute in the country that deals with issues of federalism and intergovernmental relations. So all I have to say is that I speak with some background on this about concerns about, on the one hand, implicit downloading by federal governments, not just in Canada but elsewhere, at the expense of other jurisdictions that share in the sovereignty of Canada, and the consequences incurred for those jurisdictions, which also, let's remember, have very different capacity to deal with that a province like PEI has very different capacity to deal with an increase in cases than a province such as Quebec or Ontario. And so if I was, I'm happy to try to come back to the committee and see what research I can dig up in terms of the actual costing. But if I was a provincial premier, I would not be wanting to have any of this without adequate compensation and the costing from the federal government of the additional overall costs incurred by these measures.
Oh, well, you're absolutely right, and I've talked to attorneys general who've already told us that they're absolutely flabbergasted that the federal government would, in the name of delays in the superior courts, Jordan, which is what allegedly caused this 302-page bill to be before us, that the implications of what they're doing is simply to download the expense and the additional burden on already overburdened provincial courts. As you say, 99% plus of the criminal cases already occur there. So the implications are not lost on the attorneys general. So I thought that was a very helpful point that you made in your first
Not my
submission.
numbers, but the Statistics Canada numbers that I submitted as an addendum to my
absolutely.
brief.
But I just thank you for bringing that reality to our attention here. The other thing I wanted to ask you was number 6 of your 8 points. Just to refresh your memory, that was the one about the charging, the charging provisions in British Columbia, New Brunswick, and Quebec. We've heard other witnesses already tell the committee that we have a charge approval process that the Crowns are required to do. And that has led to many fewer trials because the Crown has to be satisfied that there is, and I quote, a substantial likelihood of conviction. And routinely, Crowns say there isn't and cases don't proceed. So that would be, in and of itself, one of the best ways, I suggest, others at least have suggested, and I put to you for your comment, to deal with the clogging up of our courts, if there was a check between the police and the courtroom. Any comments on that? It seems consistent with number 6 on your list. Which I could read. It says, usually Crown or police, depending on the province, lay charges only when they believe there's a reasonable chance of obtaining a conviction. Presumably the justice system should take its course. What's the point of having a justice system when the state's overarching objective becomes to resolve as many cases as possible before they ever go to trial? I'm saying it's not a reasonable chance of obtaining a conviction. It has to meet the standard that there's a substantial likelihood of conviction. Don't you think that would have an impact if we went to that higher standard on generating less business for the courts of the land?
And as you know, and I mean, your own legal experience in this field testifies to that we already have different types of standards when it comes to warrants, for instance. So introducing these types of standards would make good sense. It also is in line with the practice with which complex cases are increasingly prosecuted, including by the Public Prosecution Service of Canada, where we now have crowns that are actually embedded with investigations and are guiding investigations. So we can actually take good direction and instruction from crowns, not simply when police are done with investigations, but throughout the course of the investigation to ensure that we can, by the end of the investigation, actually meet the standard that you propose.
I'm done?
You're past 6 minutes now.
Thank you.
Okay, so Mr. Sassi, Mr. Varani, you were gonna get a minute. I'm think Mr. McKinnon will give you his first minute to make sure you can get your 1 minute.
Is that okay? So it's a question, and it's prefaced by a comment. So Mr. Cooper raised, and one of the witnesses, Ms. Beznicki, raised the Cotter matter, and Mr. Cooper asked rhetorically, what are the priorities of the government? And they seem to be a bit skewed and makes one openly question the priorities of the government. And what I would say to that is simply that the priorities of the government are in defending the Charter of Rights and standing by the Charter. And when the government is complicit in the torture and violation of an individual, that the government should take responsibility for that complicit behavior. And it is important not to conflate, either in this committee or in front of these witnesses, the difference between terrorism that occurred in Afghanistan and torture that this government was complicit with in Guantanamo. And after 2 consecutive defeats in the Supreme Court of Canada on this very issue, when Mr. Cooper's party ostensibly believes in reducing court backlog and courtroom delay, it really begs the logical question as to why one would return to the courts, which we all seem to agree are clogged, with yet another likely failed charter claim. So apropos of that, Ms. Beznicki, if we can agree that addressing court backlog is an important imperative of this bill, is settlement of cases a way of reducing court backlog?
I'd like to respond with that the Charter, as it stands, does not define victims' rights. I worked on the Victims' Bill of Rights, and I'm only asking that my rights are regarded as are Mr. Carter's rights are regarded. I am not here to take away from Mr. Carter's rights. I'm only suggesting that as a victim, I should have rights too. Mr. Carter was a self-confessed terrorist, not enacting Afghanistan, well, perhaps the venue was Afghanistan, but was convicted and self-confessed in the U.S. I am a Canadian citizen. He committed his crime, not alleged, but convicted, outside our country. I'm only asking, as a Canadian citizen, as he is, that I have rights too. And it would appear that there is no balance in this as it stands right now. He belonged to the very organization that was complicit in the murder of my husband, Al-Qaeda. You can only imagine how I feel when I see my government give him $10.5 million for a violation of rights, and I am at the same time begging my country to afford me rights as a victim and a Canadian citizen who was married to a Canadian citizen that lived in Canada.
Pardon me? So I'll pass that over to Ron. I'll just make sure that the record reflects that Mr. Cotter is also a Canadian citizen, Ms. Bagzanecki. But your point is
Yes,
your
I
point is
pointed
well
it
taken.
out. I'd like the
Yeah.
court, I'd like to remind you that I'm a Canadian citizen.
Thank you.
Thank you.
McKinnon?
Mr. McKinnon, you have 3 minutes.
Thank you.
Okay, guys.
So I'd like to...
Guys, now you're out of order. Stop it. We have a little bit of decorum at this committee. I appreciate the passion on both sides, but we heard she defended herself very well. I don't think we need your adding in. Mr. McKinnon.
Thank you, Chair. So I'd like to address my question, at least initially, to Mrs. Wiebe. So you spoke to us about the 8-year trial and made a statement that you'd like to see all the levels of government to get together and determine what is appropriate for particular, for what is needed. And I guess in my perspective, in the evidence I've heard on this committee, is that's really the point of the hybrid offenses. They still maintain their maximums, so if there's any deterrent effect, they still have that same effect. But it allows the prosecution the discretion to, in a particular case, to decide what is the best way to proceed to prosecute. And in some cases, they will choose a summary offense as opposed to an indictable offense because that seems to be the best way forward for justice to happen. And also it means that sometimes they will proceed with the specific offense rather than pleading or charging a different offense that might be more amenable to prosecutions. So I guess I'd like your comments on that, and I would invite everyone else to follow up.
I hear many questions in your question. I don't hear just one of them. I guess let's deal first of all with the preliminary hearing, the preliminary trial, and whether that is something that can have both levels of government working on it. I mean, provincial court.
Excuse, I'm sorry, I only have a certain amount of time. So I wasn't talking about preliminary hearings, we're talking about hybrid offenses. And the fact that, or the testimony that I've heard is that they actually facilitate justice by allowing the prosecution to choose a more appropriate manner of prosecution depending on the circumstance. And allowing them to proceed with a specific offense, be it a terrorism offense or whatever, rather than charging something else that they feel is more likely to achieve a conviction. So if you could, I'd like to address the hybrid offenses kind of question.
I think that the Crown attorneys already have the right to decide what types of charges are going to be laid. In my experience in Manitoba, when a person is arrested for a crime, the police department brings the evidence to the Crown attorney. The Crown attorney examines the evidence, and my assumption, maybe incorrectly, is that the Crown attorney looks at what offenses have contravened what laws that we have, and that's what bases their decision on what charges to be laid. That has been my experience. So maybe I'm not the best person to speak to this in terms of what you're asking, because my understanding is they lay the charges according to the laws that have been broken.
Fair enough.
I wanted to say something on that issue.
Okay, please.
A 20-second intervention here. That, as I've stated in several fora in recent days, one of the issues with gun violence, this is a multivariate problem, but it's precisely that we've reintroduced discretion into a process that previously had a mandatory 10-year minimum sentence. And there's good evidence both in Canada and abroad from the data, not my point of view, but from the research that we have, that mandatory minimum sentences impose a serious deterrent on this type of violence. So there is evidence that there might be situations where discretion is perhaps not the best way to achieve the
But these are not
outcomes for public
offenses
safety that we're looking for.
We're not talking about mandatory minimums here. We're talking about maximum sentences, right? These hybridized offenses have a maximum sentence, but the fact of hybridizing them allows the prosecution to choose a summary route rather than an indictable route.
Right, but if you know as a criminal that you might end up with a choice in how you're going to be prosecuted, or there might be various reasons. I think that particular element of the law would serve as less of a deterrent than when you know there's no choice and you face a particular potential maximum.
The defendant
penalty.
does not have the choice. It's a choice of the prosecution.
Right, but the offender realizes that the prosecution has that choice, and that I think has an impact on the incentive structure that offenders use, and we do have research to that effect.
Thank you.
If I may.
Okay, we're out of Mr. McKinnon's time, but if you have something too short to add, for sure, Ms. Wiebe.
Yes, I'd just like to add that I'm talking about homicide, and there isn't a lot of leeway with homicide. It isn't like a lot of the other offenses. When somebody kills somebody, it's going to be a homicide charge.
Understood completely. If my colleagues will permit me just one short question. Ms. I'm sorry, I want to get it right. Ms. Beznicki and Ms. Beasley, I just want to, in the event that this committee decides that hybridization in some form is a good thing, not a bad thing, and decides to leave in the hybridization provisions, am I correct in reflecting that your testimony is saying that even if some elements are hybridized, there are certain offenses that for different reasons, whether moral, whether philosophical, but because the crimes are so heinous in terms of perception, that we should be looking carefully at the list and carving those out, such as terrorism-related offenses, such as in your case, the religious officials offenses. Is that basically what you're recommending? I think it is.
Absolutely.
I combed through the very lengthy bill, and there probably are a number of offenses that it's perfectly fine to hybridize, but there are some where it just is inappropriate and it sends a very, very negative message.
Thank you. I appreciate that.
I'd just like to remind this committee that the decisions that they make is not just for Canada, it's a statement in the global community. And there are some crimes, such as terrorism, that have to be recognized, that it goes beyond our borders. And I'd like to set an example in Canada and be proud of my country.
Understood completely. Thank you so much to the members of the panel. Merci beaucoup. J'apprécie énormément votre témoignage. And meeting adjourned, everyone.
Thank you so much.
Thank you.